Yeah, my lord, kindly to mention, my lord, company appeal, my lord, file,
Tushan, just hand over the slip. Then
file the original bank guarantee, which has been renewed. May I hand over a copy of the orders, my lord? 2015 order passed by Honorable Justice Shonji Banerjee and
what
Honorable
do you want
I have the bank guarantee is renewed. Leave to file the bank guarantee.
to be mentioned?
Wait, wait.
Appellate side. May I have Lordship's kindly to mention for inclusion of an appeal for the bench of Justice Bhattacharya. Urgent appeal. Order 41, Lordship, is before your
What is
Lordship.
the urgency, Mr. Ali?
The urgency is, Lordship, the house, Lordship, my residential house, that was, the bank has taken possession. Although there was an order of injunction, by the impugned order, the plaint has been returned without following, Lordship, the...
When was the impugned order passed?
This was in 7th July. We got the certified copy. We filed the appeal last week, my lord.
Already taken possession.
One has been taken, for one house there has been possession taken, but the other is not.
The bench will be available from Monday, Mr. Ali. We can't manage our own matters itself. Wait till Monday. Please.
Great.
Division being Honorable Justice my lord, the urgency is that for the landed court below, the date fix is 1st of August.
So go and appear. What is the urgent about that?
It's not appearing. I am humbly mentioning for the inclusion, nothing else. For the inclusion of this.
So what urgency is that 1st of August, the matter will be listed before the trial court?
Temporary injunction has been wrongfully rejected, my lord. And against that, my lord, the appeal. And that's why, my lord, 1st August, my lord, is for...
Ad interim ex parte was rejected.
Temporary injunction, not ad interim, my lord. Temporary injunction was heard and rejected.
On contest. Wait till Monday.
On 1st August, my lord, the date fixed.
What will happen on 1st August?
The hearing was fixed, my lord.
1st August, what will happen? Heavens will fall. Next, no.
May I have a lordship's sleep pertaining to the division bench of Justice Bhattacharya. But the impugned order, by the impugned order, the order of status quo, which was subsisting for 2 years, has been vacated. But the order was passed on 15th July, and we got the certified copy on 19th July. But the urgency is, in view of the vacating of the interim order, which was subsisting, third parties are coming and going and even making constructions or alterations inside the premises. That is why, I'm beseeching your lordship if it could be listed, any day. Grateful, my lord.
May I have your lordship's kind leave to mention a matter? This matter was supposed to be returnable today. However, it has not come up on the list. And a subsequent matter has come up on the list. So I pray your lordship to list this matter tomorrow. You count 23 of 25.
My lord, item number 2, my learned senior Bikaranjan Bhattacharya appear in online, my lord. I am for the petitioner.
The point is very short here.
Commercial.
This is not commercial.
Commercially to called holo.
Item number 2, my lord. Item number 2.
No, he is mistaken. If it's commercial, it's not my matter.
Yes, we have Mr. Bhattacharya. Commercial list has been called on.
Okay,
after
sorry.
that, non-commercial.
Sorry.
Pass over. Chalo. It can the written notes to be mentioned.
This is my application under Section 15 of the Commercial Codes Act for transfer of a suit filed before the Barasat Court, which is in the non-commercial division, now needs to be transferred to the commercial division. But if I had made an application, the application
রাখুন না, পাশে রাখো।
মানে কিন্তু
failure of the part of the lessee in payment of the lease fee or other charges due to the railway administration, the railway administration reserves the right to terminate without any prejudice to rights and available under the contract. This will lead to forfeiture of lease fee and security deposit. My lord, for this also show cause notice is required because there is a requirement of finding over here that I have failed in my duty to discharge my
What
duty.
else? You wanted to show something else.
Lordship, the earlier notice which was given by the railway authorities, which was stayed by the learned commercial court at Rajarhat, which is at page 348. My lord, if I may place it, this is dated 9th of April 2025. Top right hand corner, my lord, the date is there. My lord has got it. If I may place it, my lord. In reference to your communication under clause 9, the following remarks are offered for your information and necessary compliance. They asked me to comply. What is the deviation? Non-communication from engineering department. As per your own submission, no formal intimation or communication has been received from the concerned engineering department regarding the stated issues. This omission from your end is noted with concern. Court proceedings and unauthorized commercial use. You had challenged the stoppage of work by the railway before the Honorable High Court at Calcutta. The judgment is quoted, where judgment was delivered on 10th of May 2024. Despite the verdict and without affording the railways an opportunity to respond, you have continued commercial exploitation of railway assets without fulfilling core contractual obligation. Specifically, adherence of timeline. There were two allegations against me, which is I did not adhere to the timeline, and the other is payment of lease fee. Lordship, upon a finding that there was no imputation against me that I could not, due to my lacuna, that the timelines could not be adhered, or that there was no payment of lease fee, the court, the Honorable, the learned commercial court at Rajarhat, stayed this notice. Lordship, if I may, if my lord kindly turns over the page at 349, the conclusion. There are only two allegations again. It is evident from the above point that you have multiple and repeated violations from your end concerning both clause 8 of the contract and clause 3.6.16. Lordship, even if I consider this as the show cause notice, after which they could have terminated, at least 3 months notice ought to have been given to me. This is dated 9th of April 2025. 3 months takes me to at least 9th of July 2025. They terminated on 23rd of June 2025. At least that period should have been given to me before they issue the termination notice. On that score, Lordship, I'm praying that this notice of termination at least be temporarily be stayed, because I have given notice to them, I've replied to them. This notice also has been subsequently stayed by the learned commercial court at Rajarhat. The contracts clearly specified a 3-month clear notice. Even the best case scenario for the railways that this is to be construed as the show cause notice, the 3 months period takes me to 9th of July 2025, going by the date of the notice. Although it has been received, from the date of receipt, the 3 months will be counted. Even if I go by the date of the notice, that on this very same day, the notice has been received, it takes me to 9th of July. The termination notice is admittedly dated 23rd of June.
You're satisfied?
My lord, I will only be satisfied when my lord interferes with this illegality, my lord.
Oh, that was not the condition. We just permitted you to raise certain documents.
My lord, if my lord is not passing, my lord, then kindly grants time. My lord, pass over lordship, just.
No.
My lord, Mr. Bhattacharya.
Certainly not. Not after hearing you for 10 minutes, no.
My lord, then may I just place this order of the 30th June where the finding is there that I have fulfilled both the conditions on which
You're
the show cause
killing
notice.
time so that Mr. Bhattacharya arrives.
Absolutely not, my lord. My lord, that is material, my lord, because it is clear violation. 3 months notice is stated in the clause
We'll record your submission. That is, you're saying it's violation. We'll record it. Don't worry.
My lord,
But even then, we'll say that it may be wholly illegal what they are doing.
My lord, but my investments, the project was only for development of a sports complex.
Recover, get an award. Get an award.
My lord, the award will subsequently take time, lordship. What about my investments over here? I have suppose this was a public-private partnership.
Now costs will go up. You want to withdraw, we can give you that choice because we are telling you we are dismissing your appeal.
My lord,
The observations we'll make, which may not help you. That is why we are asking you. It is better we pass an order. Don't take anything on your shoulders. It is better we pass an order.
My
This appeal is directed against an order dated July 4, 2025, whereby
my lord,
this was ex parte you had moved.
this was expert. My lord, may I just make one submission? My lord, if I may be allowed to withdraw this section, I'll pursue it in the section 17 before the
Better,
arbitrator.
better. We'll do so because of the very nice manner in which you have placed your case. According to us, your case has no merits, but that is not your fault. After making submission for some time, learned advocate for the appellant prays for leave to withdraw this appeal with liberty to proceed with other remedies that it may, with liberty to take recourse to proceed, take recourse to other remedies that the appellant may have, in accordance with law, including approaching the arbitral tribunal under section 17 of the Arbitration and Conciliation Act, 1996, paragraph. Such leave is granted. Stop. This appeal is dismissed along with the connected application. Stop. We have not entered in, we have not addressed the merits of the appellant's case at all. Stop. Any other forum that the appellant may approach is requested to decide the appellant's case independently in accordance with law. What is your good name, please?
Surjonil Das, my lord.
Surjonil Das.
My lord, grateful for the patient hearing, my lord.
My lord, revocation of leave under 12A allowed.
If for the respondent number 1, I would raise the point that it's not maintainable before my lord, not appealable order. Yes, yes. The other high courts have held.
We are, Mr. Shah, we are actually hearing this exact point. Mr. Orin Chakraborty is the appellant.
My lord, it's covered already by your lordship's division bench.
What?
The question of appealability.
On the contrary, it's covered by.
It's completely covered. It's completely covered. Let me show you, my lord.
No, that an order revoking 12A leave
Yes.
is appealable.
Yes.
This is covered.
Yes.
The issue is different.
The.
In appeal before my lord in the commercial division from an order.
Let me show you the order. There's no point in my lord going into the controversy. I'll show it right now.
Because it's not.
Correct. So it's covered. It's
under order 43.
You don't have a copy for the judges? Give the copies. My lord, kindly just have open 113. My lord, kindly have, my lord, my lord, our DB in the matter of Srishti infrastructure reported, my lord, in unfortunately, my lord, Manu Patra. Manu stroke WB stroke 1688 of 2024.
Srishti is not that.
This is not that issue, my lord.
Yes, let me show, my lord, what the issue is, my lord. Give me half a minute, my lord. A copy though, na copy though. My lord, kindly have. My lord, I have given you a compilation of this judgment. My lord, kindly, my lord, have, my lord, page 113, 19, page 119. Now, my lord, you gave this to me separately. Where is my compilation of this? No, no, no. Where is my small one?
Best to respect
It
is not on the point, my lord, which I am stating before.
True to form, my lord, Mr. Banerjee wants to move my application always. But, my lord, yes.
To get it dismissed. All right.
Let me move it, then you'll get it dismissed.
All
My
right,
lord,
please.
kindly have this, my lord.
Mr.
From, my
Shah,
lord,
you come to paragraph 10. The point urged first and perhaps the foremost objection taken by the respondents in the appeal, impugned judgment order is not appealable. So this point was taken.
yes.
Did you
My lord,
see
your lordship is seeing, my lord?
paragraph 10 of the judgment?
Yes.
Last sentence of paragraph 10.
Yes, I'm so grateful. Yes.
Right.
Yes.
Now come to 121,
Yes, my lord.
paragraph 14.
Yes, my lord. Learned tribunal for the learned counsel for the respondents went to the extent of arguing that section 13 of the Commercial Court Act did not permit any appeal from a decree. No doubt the wording of the section is ambiguous in many places, yet it would be absurd to think that the said act dealing with commercial cases debarred appeals from a decree, which is the final adjudication in a suit, which necessarily includes a commercial suit. Now, my lord, pausing here for a moment, my lord, I'll just tell your lordship, my lord, what was considered. My lord, rejection of, my lord, leave granted under section 12A is deemed to be a rejection, my lord, under, my lord, order 7, rule 11, which means, my lord, the suit itself is being decreed. And their lordships, my lord, the division bench held that, my lord, it is perhaps, my lord, not correct to suggest that, my lord, once a decree is passed by the commercial court, then that is not subject to any appeal. So, my lord, that is, my lord, the reasoning. And, my lord, on that ground, my lord, it has been held, my lord, to be appealable. You all are giving me I have a flag mark.
Actually, শোনা উচিত না, ওটা একটু যখন শুনেছি মাইকেল করেছি, এত মোটা একটা কম্পাইলেশন দিয়েছে আমাদের।
My lord, kindly, my lord,
Please.
permit me, my lord, to lead your lordship, my lord, in this judgment, my lord, from, my lord, kindly, my lord, take it from paragraph 3 onwards, my lord, I'll just take 5 minutes of your lordship's time. By a detailed examination of the plaint, the learned judge went into the question whether an interim relief was contemplated in the suit. She ruled that no such interim relief could be said to be contemplated. By a judgment and order dated so-and-so, the plaint was rejected. The other application for interim injunction and for rejection of the plaint under Order 7, Rule 11 were rejected as redundant. So, my lord, I'm sorry. Take out section 13. Because my lord, before I lead your lordship to this, I'm sorry. Thank you. Very good. Very pocket.
Then why was this not Mr. Banerjee in the other matter? We are surprised. Clearly, the division bench has held that this order is appealable.
Because, my lord, it has not been argued. I'll show it. This has gone up to the Supreme Court. Supreme Court has also held, as my lord has held in the other. I'll show that judgment.
Has held what? Not appealable.
Not appealable.
Who was that?
Yes.
Who was that?
This matter, Supreme Court has held in other matter.
Who was that?
Yes, I'll show it. Well, once he finishes, I'll show all the high courts as well as the Supreme Court.
No, let us not spend much time. If Supreme Court has spoken, then that's the end of the matter. Let us see.
Because of the
Otherwise,
the statute.
otherwise, Mr. Banerjee, otherwise we'll have to follow Srishti.
Yes, because, my lord, Srishti has not considered this issue at all. Kindly sees, my lord, 13.2. Kindly see
Which issue?
this issue, my lord, that a order or a decree. So even if it is a dismissal, if it's a decree, my lord.
No, it
then
has been
also
considered. Mr. Banerjee will read, my lord Srishti. It has been
I
considered.
have seen
That's exactly the point.
paragraph 16, 17.
That's exactly the
18.
point.
Show your Supreme Court.
Yes, kindly sees, my lord, 13.2 and then the Supreme Court.
Does it say that,
It's not appealable.
one second, does
Copy
it
them.
say that an order revoking leave under clause section 12A of the Commercial Courts Act is not appealable?
It's not a question of, my lord, on 12A.
This says it is appealable.
No, my lord, kindly considers, my lord, if 12A is revoked, it's a dismissal of the suit under Order 7, Rule 11, which, my lord, ultimately culminates into a decree. Now, 13.2 says, my lord, no order or decree. Kindly sees the language of the statute. It says, my lord, notwithstanding anything.
No, this has been considered by the DB.
Not-
No,
something.
because
Let
it's
him
my
complete,
point.
my
Let me complete, my lord.
Lordship
Because
asks me, so I am, my lord, saying. Otherwise, I wouldn't let him complete, then I'll show, my lord.
Sure.
Let him, all I have given, kindly sees, my lord, notwithstanding anything contained in any other law for the time being in force or latest patent of a high court, no appeal shall lie from any order or decree of a commercial division. So it covers decrees also. Now, my lord, kindly sees this judgment and kindly comes to paragraph 14, my lord.
copy the.
Kindly sees paragraph 14, my lord.
Thank you.
My lord, kindly sees, if I may read, the proviso goes on to state that an appeal shall lie from such orders passed by the commercial division of the High Court that are specifically enumerated under Order 43 of the Code of Civil Procedure 1908 and Section 37 of the Arbitration Act. It will at once be noticed that orders that are not specifically enumerated under Order 43 CPC would therefore not be appealable. And appeals that are mentioned in Section 37 of the Arbitration Act alone are appeals that can be made to the Commercial Appellate Division of the High Court. Thus, an order which refers parties to arbitration under Section 8 not being appealable under section 37(1)(a) would not be appealable under section 13(1) of the Commercial Courts Act. Similarly, an appeal rejecting a plea referred to in subsection 2 and 3 of section 16 of the Arbitration Act would equally not be appealable under section 37(2) and therefore under 13(1) of the Commercial Code. So far, so good. However, it is such and such main argument, section 50, this goes on with the others, my lord. So therefore, my lord, it's absolutely, my lord, clear that no appeal lies, my lord, from an order or a decree in terms of section 13, otherwise which is not covered under, my lord, order 43. And, my lord, other high courts also I can show, my lord. So it's not a question of, my lord, revocation or, my lord, other orders, my lord, which has been.
Mr. Bhattacharya, when have we kept that matter where you are the amicus? Come back tomorrow at 3:30.
Yes.
Please.
May I-
3:30.
Yes.
Tomorrow there's a reference, of course, that we'd have to refix it. No, normally in the middle of the week, it was not risky.
We have it on Wednesdays also. Midweek one, my lord, we have.
Kalki,
You can come back early also if your lordship. At 2 o'clock.
But may I just indicate one thing?
why we, Mr. Shah, why we want both of you to come back? We have
I will come back.
appointed Mr. Bhattacharya.
I
as
will come
amicus.
back and, my lord, I
He
will,
has
my lord,
handed up a fat compilation to us, which we will just glance through.
Yes.
my lord, the
I
amount
can
of,
also
my
see
lord,
that.
the amount of time courts all over India have given to section 12(a) of the Commercial Courts Act. I don't think, my lord, any other provision of law anywhere in any act has received that kind of attention.
Within such a short span.
No, at all. With long, short, my lord, I don't think, my lord, any other provision of law. My lord, I only wanted to indicate one thing. Now, my lord, on the 1st of May, your lordships had granted me an interim protection in this matter, in, my lord, another appeal. And, my lord, on the 1st of May, your lordship has said that that order will continue for a period, that protection will continue for a period of 2 months, and the trial court will decide it in the meantime. Now that the suit has gone, my lord, they can invoke, my lord, this, my lord, amount of 25 crores, my lord, which I want to restrain. So, my lord, I am, my lord, I am, my lord, tempted to remind your lordship, my lord, of, my lord, those line of cases, my lord, starting, my lord, Justice Jyotirmoy Bhattacharya's cases, that, my lord, even if there is a point of maintainability that is urged, my lord, interim order can be passed. So, my lord, I just want to show your lordship one paragraph, and then I leave it to your lordship.
It's not maintainable. So question.
Yes,
of
even
publication
then, my
of
lord,
order-
even then, my lord, that is the law.
There
That is
an
the law.
Inherent lack of jurisdiction, my lord. Perhaps this is not correct at
Yes.
all.
Well, that is his submission. That is not yet, my lord.
That will not
My lord, may I just, my lord, may I just,
against my client, not a party to the
my lord, may I just, my lord, indicate?
that interim order, which my learned senior friend is Milord,
Kindly, my lord, once have,
will be Milord against my client, who is not a party to the proceeding.
my lord, kindly, my lord, once have.
The bank, Milord, is
He
not a
doesn't
party.
want to be a party. He was asked to be a party.
Milord, that is not actually correct. The dominus litis
Mr. Bagh, may I just finish? You will have your turn, I'm sure. I'm sure you will have your turn.
Is the 29th. 12 দিনে হয়নি, কালকে শুনলে invoke হয়ে যাবে আজকে। Mr. Shah, Mr. Shah,
Yes,
the impugned order is dated 17th of July.
Yes.
In 12 days, nothing has happened. In 30
No, my
days,
lord,
something will
my lord, I'll tell your lordship, my lord, Mr. Bagh's client is 10% owner, my lord, of the D1 company. So, my lord, if he has given a loan to his own company, of which he is more than 10% owner, then he has to just pick up the phone and say, please release the money. So, my lord, that is, my lord, the next, and I already have an interim order. My lord, my lord, my all that I'm saying is, if I have been protected by your lordship upon a very contested hearing, then, my lord, merely because, my lord, they have gone, my lord, and obtained the dismissal of the suit, my lord, I should not be, my lord, left, my lord, floundering. And I'll tell your lordship, my lord, when your lordship passed this order of 1st May, they never took the point, my lord, that revocation, because your lordship said, decide this issue within 2 months.
These are all on merits, my lord.
No, I
and
am not
he is
on the
an
merits.
owner of
Kindly,
my
my lord,
company.
just have page 77.
These are all on merits, my lord.
Kindly just have page 77, my lord, for half a minute.
Submission is being made, but then I'll make submissions on merits.
And my company is not
Show me,
owned
show
by
me this, show me,
IDFC
show
Bank,
me
my
this
lord. I don't know
paragraph.
where he's getting this, that he's a shareholder in my company. আমার কোম্পানিতে তুমি কবে ওনার হয়ে গেলে তো আরবিআই গাইডলাইন্স দিচ্ছ তুমি বাবা জি সে তো করছো কোম্পানি ফুল ফান্ডিং
But may I take your lordship's kind?
Milord, just Milord, indulge me, Milord. Taking one order at page 70, the order starts at page 81. Page 70, Milord, is your lordship's order of 1st May 2025. 77, I'm so sorry. 77 is your
Mr.
lordship's order of
Banerjee,
1st May
Mr. Banerjee, we
2025.
propose to do this. Let us not really, waste more time on this than is necessary. We'll have to hear out this matter. Prima facie, we find Srishti staring at us. Prima facie. Not a final finding on our part. On that basis, we say prima facie maintainable. We'll decide the issue at the final hearing, which will be tomorrow or day after tomorrow. And 7 days or whatever, interim order.
No, my lord, kindly, my lord, my lord,
Yes, my lord, may I show your lordship the interim order that you had passed so that, my lord,
my lord, kindly,
just, my lord, kindly, act second.
What is weighing with
Kindly
us
take
as
page
there
80.
was an interim protection granted by us.
No, not at all.
Yes, let me show that. Let me show that.
Let me show this, my lord.
Why will you show? It's my petition. My lord, page 77 is the order.
Not say something
Page
which is
77 is my order.
law.
Mr. Banerjee,
not
please,
lordship
let's not
to
speak
hear
over
us.
each other.
Let's,
My lord,
lordship
page
to-
77 is the order. Page 77 is the order.
If Mr. Shah does not stop,
Mr. 77 is,
my lord, finish off.
yes, please do, let me do that.
Yes, yes.
Page 77 is the order of, my lord, 1st May 2025. Now, my lord, kindly come to page 82. 82 to, no, 81, I'm sorry. 81. The second paragraph at, my lord,
Yes.
for a period of 2 months from date, the defendant number 1 shall go on paying the equated monthly installments to IDFC as it has been paying in the recent past. Defendant number 1 is Mr. Shatru Banerjee's client. Defendant and IDFC, my lord, is Mr. Bag's client. For a period of 2 months, the defendant number 1 shall go on paying the equated monthly installments to IDFC as it has been paying. However, keeping in view the fact that the plaintiff has raised an arguable point as regards superiority of its debt, which would have to be decided upon interpretation of 2 RBI circulars and upon examining as to whether both of the said circulars or any one of them is applicable to the facts of the present case, as also the extent of applicability thereof, if at all any of them is applicable, we feel that it would be just and proper to direct that for the said period of 2 months, nothing more than the equated monthly installment should be paid to IDFC. So, my lord, IDFC, my lord, was being paid in installments.
To the trial court to decide on merits.
Their claim has matured. They are now entitled to get a bullet payment of 25 crores. That has been restrained. So, my lord, I have no problem with the my lord, monthly payment of installments that is continuing, but my lord, that has come to an end on 1st May. Now, my lord, that 25 crore bullet amount, my lord, which, my lord, has been advanced, my lord, to Mr. Banerjee's client, my lord, by the IDFC Bank, has become, my lord, matured for payment. They can make payment, my lord, in the next 5 minutes. So, my lord, that is what your lordship had restrained. And I'm a little surprised that Mr. Banerjee says, my lord, there's no interim order.
May I now, my lord? First of all, my lord, Mr. Shah said that a bank IDFC is 10% shareholder in my company. I want him to show it before the court today or tomorrow. Now, my lord, kindly comes to page 49. This is exactly what he tried to do, my lord, and bulldoze before the trial court. By giving an impression, kindly comes, my lord, this is an order of 17th of January 2025, passed by the division bench of this court by Justice Sen, where, my lord, the issue of 12A was raised. The court, my lord, considered the judgments. Lordship will find, my lord, at page 54, the Gabriel judgment considered at paragraph 9, page 54. Then, my lord, will see The other judgment which has been considered is at page 56, Patel Automation at paragraph 12. Then Lordship will find, my lord, at paragraph 57, sorry, my lord, paragraph 13, page 56. My lord, the Srivardhan investment judgment considered. Then, my lord, Yamini at paragraph 14 at page 57 has been considered. And then Lordship will also find, my lord, at page 58, the other judgment of Harish Verma being considered. And my lord kindly sees at page 54, Shrishti has been also considered. Paragraph 9. Lordship will find. Now, my lord, apropos this, kindly takes, my lord, the direction of the Honorable Division Bench of this court, which has not been appealed against. Now, kindly comes to page 61. Or, my lord, may I read from 60? 60, paragraph 19. Paragraph 18, my lord. Kindly sees this. This is exactly what he has done before the trial court who has rejected the, my lord, suit or the plaint. Kindly sees. The impugned order prima facie shows that preferential treatment was given to the plaintiff, that is my learned friend's client, as regards repayment of the loan or advances by the plaintiff over other creditors. IDFC First Bank claims to be one of the creditors, not, my lord, a shareholder. That other creditors may be affected by an order cannot dilute the legal right of the plaintiff to secure its claim. In the event of establishing its legal right, notwithstanding at the initial stage, the court should be circumspect not to pass any drastic order that may cause breach to any existing obligation or procuring a breach of a contract. It is only upon whole facts that are brought on record and to the notice of the court, the order of attachment or injunction as the case may be, depending upon the facts of the case. Now, kindly, my lord will mark this. The learned trial court has referred to a few decisions wherein appropriate cases and order of attachment or injunction could be passed. In view of the fact that the appellant has made a payment of a sum of 1.5 crore after the impugned order was passed and is willing to pay some and also agreeable to have an amicable settlement of the dispute to which the respondent at this stage expressed its disinclination, we vary the interim order to the effect that upon appellant making payment of rupees 2 crores and filing an affidavit of assets and schedule of payments in respect of other creditors, the appellant shall be permitted to utilize the rest of the amounts. Kindly mark this, my lord, injuncted by the impugned order. So there is an order that this amount can be utilized. Then, my lord, the appellant shall file an affidavit in opposition to the injunction application within 2 weeks from date. Reply thereto, if any, shall be filed within 10 days thereafter. In the event of compliance of this order, it would be open for the appellant to pray for preponing the date of hearing of the injunction application. In the event, this is very important, in the event of any application for revocation of lease under 12A is filed, it shall be heard only after compliance of this order. Then, my lord kindly sees the appellant shall file fortnightly statement of accounts in pending proceeding upon service. Now, we complied with this. There was an extension given to file the affidavit in opposition, which we complied. No appeal against that. When the matter came up, my lord, before the trial court, Mr. Shah tried wholeheartedly, showing my lord's two orders, which were not against me, but against, my lord, a dispute with my learned friend's client, saying that, lordship, that the trial court cannot hear in terms of this order the revocation application filed, but has to hear the applications which he has filed with regard to, my lord, who will get the credit facility or who will get the interest prior, and tried to stop the proceedings, which, my lord, we, my lord, opposed. The trial court considered this order since there was no appeal against this order, and, my lord, has rejected the plaint. Now, my lord, coming up today saying, my lord, that he is, my lord, so much, my lord, aggrieved by the order, my lord, doesn't lie, because he tried something, he failed.
What did it
This order, my lord, of Justice Sen has not been appealed against or set aside, not even considered, because, my lord, the appeal that was preferred before, my lord, against the two orders was against my learned friend, nothing to do with me.
That exactly that order we propose to continue for 10 days and hear out the appeal.
Justice Sen's order, my lord, was on 17th of January. Your lordship's order is on 1st
If it is
of
against
May.
him, it is against him.
So, kindly sees one line which he says, my lord, that, my lord, payments to the other creditors will continue. That is there, which he has not got
Yes,
right.
but the bullet payment cannot be made. I agree.
Payment today is not part of the submission.
That is the exact order that has been passed on 1st May. I don't want any variation of this order.
Therefore,
This order is 17th January and your lordship's order is of 1st May.
yes.
And he feels, my lord, and he's not gone in appeal against 1st May order.
Oh,
And therefore, my lord, he says, my lord, that order will prevail. That order says nothing.
May I submit?
Yes.
I'll be affected, but my client will be affected. So may I quickly indicate, and it's very brief. The
My lord, if he
premise
doesn't
of
take
my-
the money, your lordship will decide the issue for 7 days, let him 10 days, let him not take the money. That's all.
But this is a different contract altogether, not a list, my lord, in between this, my lord, in this suit. It was not a list, my lord. Kindly permit me to show 3 documents, and that's where I'll, my lord, stop.
My lord, your lordship is not hearing the matter afresh.
I'm
The
not
only question is
any
that, my lord, there was an interim.
Very well. Allow him to place 3 documents,
Very-
he said.
very briefly, my lord. First, since it is, my lord, my learned senior friend's client who's the plaintiff in the proceeding. Dominant plaintiffs, my lord, they are in charge of the carriage of the proceeding. They know who to make a party. Kindly see the pleading in their injunction petition, which is akin, my lord, to the plaint. Kindly take up, my lord, page 156, volume 2.
Read out.
Paragraph 25. In fact, the defendant number one's email of 19th November 2024 issued to the plaintiff reflects a subdebt tier 2 has been repaid to Capital First IDFC Bank Limited. Copy of the covering email along with its attachments, balance sheet and plot details are given. They make pleadings against IDFC Bank. They don't make IDFC Bank a party. For very consciously this is done, Milord. Otherwise, Milord, we would come and immediately object that it is a part of a different contract which is not to which, Milord, these
Where is
parties
the-
are not privy.
Where is the?
The defendant here in this proceeding, Milord,
You are
today,
IDFC First Bank Limited.
IDFC First Bank
Where is the-
Limited.
where is the- where is
Milord,
the
today we
patent?
are not a party, consciously not made a party by the plaintiff, number one. Number two, Milord,
But you were a
our
party
rights-
before us.
That is because, Milord, we had an application. Milord, we are still not a party in the proceeding. We, Milord, have made an application. Milord, we did not have a list. in
Please
fact.
tell the court that you
Let me
declined to be a party in the
Give
proceeding.
5 minutes. I have only 5 minutes
Show
to
me
indicate
those
Milord, what is
cases
how
I don't
is
want
it
to be
that
part
we are going to be affected in the entire proceeding. Milord, this list is between the plaintiff and the defendant for a contract. A loan
This
was
court
given.
is-
There was a default. It's for them to fight out, not for us. Our Milord, we come in at a stage when the honorable court, the learned court, Milord, Rajarhat Commercial Court passes an order. Till then, Milord, we had no dispute. There was no reason for us to intervene, Milord, to file a pro inter SSO. That's what we had filed. And at a stage when there was an observation in that order, one line saying till this payment is made, till this repayment of loan is done to the defendant, all the other creditors, you will not be paying any other creditor. Any other creditor would include us. We are exposed to a different contract where we have given them loan. So, Milord, today by that order, Milord, my repayment of loan gets affected. 10% shareholding, which Mr. Shah, my learned senior friend, is indicating again and again. But Bacha, of course, that I don't get to become, Milord, the owner of the company. It's 10% shares, and that too, Milord, if I show the affidavit used to the petition which I had filed pro inter SSO in the trial court, it is very evident, Milord, that this defendant and we, Milord, IDFC Bank, are never in hand in gloves. Milord, today the difficulty is if this order is passed, Milord, today my right has ensured from June. Milord,
Why did
where
you take away
this
my
was
paper?
the date by which they had to make this repayment. I'm sorry, Milord, stand corrected. That's 1st May. So, Milord, we are under.
Shivag, what you are not following is that from 1st of May, let us see, you have suffered an order.
We have.
We granted 2 months interim protection because we were of the view the dispute on merit should be considered by the trial court, consider all those circulars, whether they are applicable or not, etc., etc. Now that decision on merits has not come. 12-way revoked suit is rejected.
I bow down, Milord. Today the suit is.
So if today, that is, we'll restore it for the time being. That's what we are saying. We are going to pass a limited order of stay, prima facie being satisfied by Srishti that the appeal is maintainable, and we will decide the issue of maintainability first, and then rest of it. And we'll do it very soon. Yes.
What is falling from your lordship.
Yes, that is all. That, yes, yes.
May only make this submission, Milord, because today, Milord, if this order is for a limited period also,
Yes.
Milord, my right as a bank with an independent contract, my right to enforce that independent contract, Milord, today, that is what, Milord, I was indicating. I can give it 2 more minutes, Milord.
Then why did you not challenge our order dated 1st of May?
by that order, because that order, my lord, was for a limited period when my right did not crystallize. So, my lord,
No, no,
till
it
then,
did. First
sir,
May.
may I-
That's not a correct submission.
I
Factually incorrect.
did not crystallize, no, because that order was for a limited period. By then,
But
my right
you-
was repayment of loan.
Your right crystallized on the 1st of May.
Correct. Yes.
Yes.
Bullet payment was due on
Yes,
1st
yes,
May.
I remember that. We both remember that.
My lord, today, if there's an order, my lord, by which it's a limited period, my lord, by which this had to be decided only on that limited point. But today, my lord, if the suit is not there, then, my lord, my list goes, because my list is only for that one line of the order, which was thereafter, my lord, considered by this honorable court. May I quickly indicate page 60?
Hmm. Tell us a convenient date and time, all of you.
Tomorrow itself, since it is fixed, we'll come back tomorrow.
3:30, so there's a reference that yes, we have to rise at 3:15 tomorrow. For late Bhaskar Sen, na, we have
Yes.
a reference tomorrow. Porshu din hobe.
My lord, can it be on my lord, on Friday?
We are
That will
seeing
be
that.
the
Friday ki date ta ki bol?
I'll make submissions, very short submissions. Because
1st
today
August.
I cannot really make submissions on when this is maintainable.
First,
Not
no.
my
First on appealability. That is what
friends.
1st of August, my lord.
The second.
Hobe.
My lord. My lord, may it be second, my lord.
Second.
Fix
Second
করা
on
আছে?
Saturday.
Oh, Saturday.
পরশু মানে বৃহস্পতিবার।
The first is all right, my lord. 1st August.
First
1st of August is all right. For
1st of August,
Friday, my lord.
1st of August.
12:30 fixed আছে। 3:30 is useless on a Friday.
So 2 o'clock, my lord, if we come back at 2.
Oh, it's a different bench second half.
Oh.
Monday? Monday you are all here.
4 তারিখ
Monday?
নেই, 4 তারিখ নেই।
ফাঁকা আছে? Monday 3:30.
3:30, my lord.
Monday 3:30 is quite safe.
No, I'm saying, my lord, whether we'll finish or not. That is what I'm saying, my lord.
But then next day again we'll give you time. We can't ignore all other cases.
No, that's all right, my lord. We'll come back at 2.
Sure, sure.
Will your lordship permit us to come with a small note, my lord? Then just
All of
make
you.
submissions, my lord. And
All of you, whoever wants
my
to.
lord, that, my lord,
Bullet
may have
form.
the effect of, yes.
Yes.
My lord, my difficulty with IDFC Bank, my lord, is that we were not party to the proceedings.
Because he specifically page 168 first
It
line.
has been set aside.
I don't want to be a party to the proceeding. 168 first line.
Party even
Page 168 first line. Kindly permit me to place it. This is from his application under the petitioner does not intend to be added as a party to the
Yes,
present suit.
application is pro interests, so
Correct.
the rights are to be, my lord, protected. That is why
Correct,
we
correct.
filed that
So, my lord,
application.
My
Not
lord, only
intending to be a party to the proceeding.
correct.
only one request we have, my lord, all of us, I believe, my lord, if lordship writes one line directing the amicus to, on request, to give a copy of his compilation.
Oh, he told us in
No,
front of
my lord,
you
on
that he'll
request,
give.
not to all. Whoever makes a, my lord, issues a letter to him, so that we come prepared with the points that he has taken, my lord.
He would probably be arguing that it is appealable. So therefore, you better consider.
Exactly. That is why, my lord, I'm asking.
Issue.
Mr. Shah may not require it. I will.
Also consider, both of you, all of you, Dhanbad. What?
Yes,
Dhanbad fuels. Dhanbad
Dhanbad
fuels.
Yeah.
That's
But
the main, my lord,
that
12B
is the
line.
that is the judgment considered by the trial court in dismissing the appeal, in dismissing the plaintiff.
This appeal is directed against an order dated July 23,
17.
17.
July 17.
2017, comma 2025, comma, whereby the learned judge, comma, commercial court at Rajarhat, comma, North 24 Parganas, comma, rejected plaint of MS Com -156/2024, comma, being a suit filed by the appellant herein, comma, upon revoking leave granted to the appellant oblique plaintiff for dispensation of the mandatory pre-litigation mediation under section 12 capital A of the Commercial Courts Act, comma, 2015. Paragraph. A preliminary objection has been taken on behalf of the respondents that the appeal is not maintainable. Stop. Paragraph. Mr. Shaha, learned senior counsel appearing for the appellant, cites the decision of a coordinate bench of this court in the case of Srishti Infrastructure Development Corporation Limited versus Shargo Hotel.
Sarga, S-A-R-G.
Sarga.
That's
Sarga
the
Hotel.
Western Hotel, Milordin. That's the Western Hotel.
Sarga Hotel. I thought it was Shagor misspelled as Shah. Sarga Hotel Private Limited.
Anglicized
Decided
version of Shorgo.
decided on August 23, 2024, in FMAT 222 of 2024. Stop. Relying on the said judgment, Mr. Shaha argues that it has now been settled by the division bench of this court that an order revoking leave under section 12 capital A of the Commercial Courts Act, comma, is appealable. Stop. Paragraph. Mr. Banerjee, learned counsel appearing for the respondent number 1, strongly disputes the submission made on behalf of Mr. Shaha. Stop. Relying on Kandla, no?
Yes, Kandla.
Kandla, relying on the Supreme Court decision in Kandla Export Corporation and another versus Eta, reported at such and such. He says that an order of the nature as is impugned in this appeal is not appealable. Stop. Paragraph. We have to decide this point upon considering all available authorities and hearing submissions of learned counsel. Stop. In another matter, comma, this identical point is involved, which we are hearing. Stop. In that matter, we have
Good faith matter, my lord. Good faith.
good faith.
Yes, my lord. It is
Another matter, the namta likhe
Faith
dao.
Holding Private Limited versus Messrs Supreme Wood Products Private Limited.
Just jot down and give it to
Yes.
him, please. And in that matter, on our request, comma, Mr. Rudroman Bhattacharya, comma, learned senior counsel, comma, has very kindly agreed to appear as amicus curiae. Stop. We had fixed that matter for hearing on Calcutta date thou at 3:30 p.m. Stop. However, there will be a full court reference in memory of a senior lawyer of this court who passed away recently, date I forget when. Anyway, recently, comma, tomorrow at 3:30 p.m. Stop. Hence, we refix the hearing of that matter and this matter, Kavibullam,
Fourth at 3:30.
on August 4, 2025, at 3:30 p.m. Stop. Paragraph. Prima facie, we are of the view that the decision in Srishti has decided the issue of maintainability. Stop. Hence, we admit this appeal without prejudice to the contention of the respondents as regards maintainability of the appeal. Stop. Paragraph. We see that on an earlier occasion,
Page 77 at 81.
the appellant had come up before us by filing FMAT 3 of 2025. Sorry, na bhul bollam. AOCOM 5 of 2025, challenging two orders dated March 26, 2025 and April 8, 2025. Oh, আচ্ছা ওইখানে AOCOM 5 of 2025 and
Stroke 7.
and AOCOM 7 of 2025. দুটো appeal ছিল। Orders dated such and challenging orders dated March 26 and April 8, 2025. Passed by the learned judge, commercial court at Rajarhat. Stop. We had
Page 81, bottom.
disposed of those two appeals by a judgment and order dated May 1, 2025, the operative portion whereof reads as follows. Page 81, 82 থেকে set out করে দাও। Paragraph. Since the appellant, oblique plaintiff, was enjoying that order for some time, we are of the view that that order should operate for the next 10 days. Next 10 days or until further order, whichever is earlier. Stop. Accordingly, we so direct. That is all, no more today.
We'll come back with a short note. I'm so grateful. Deeply obliged. Yes, whatever is there, my lord.
No, now it has become operative again. We have passed today.
Whatever is there is there.
Yes,
Whatever is there is there. Absolutely.
My lord, only that
I'm
one
deeply-
line, my lord, whoever makes a request for that compile.
Oh yes, paragraph. Whichever party through its learned advocate makes a request to learned amicus curiae for making available a copy of the compilation that learned amicus curiae has filed in court, should be supplied with such a copy.
Affidavit of
Upon it's a very
Usual cost, my lord.
on payment of usual costs.
Deeply obliged. Very great.
May only one line be not indicated because here it's not that nothing more than the equivalent monthly installment will be paid to IDFC.
No, the first.
Got it, my lord. I'm only beseeching you, Lord, that one line.
It's there already, my lord, in the first paragraph, in the paragraph, the first line of
We
the
have set
paragraph.
out the order.
Yes, it's there.
ওখানে এটা সেট আউট করার পর যেখানে কি বললাম দেখো সেট আউট করার পর অপারেটিভ পোর্শন সেট আউট করলো তো তারপরে কি বলে we have the view that order should operate for the next 10 days. Stop. In other words, the appellant shall go on paying the
No, not the appellant. My lord, Mr. Banerjee's client will go on paying, Mr. R1 will go on paying IDFC.
the respondent number 1 shall go on paying the paying what? Go on paying equated monthly installment to the respondent number 3.
Because this month.
Respondent number 3 in terms of this order. Read with the order dated May 1, 2025.
Without making payment of the bullet amount, my lord. Very well. So this portion was also there, my lord, the first line of that paragraph.
I'm very deeply grateful. Very deeply.
Come back.
Grateful.
We'll ensure on Monday we are not there.
Mr. Shah will not let that happen. Madam. He has heard
Yeah,
10
speak for
days.
both.
10 days, na? Interim order. So, नहीं आज.
मतलब 7 है एपीएफ फॉर द एप्लिकेंट मतलब एपीएफ फॉर द रेस्पॉन्स और बिट कोথায়
Tranquilo.
थोड़ा एपीएफ फॉर द एप्लिकेंट मतलब comply with the direction मतलब filing of reply.
Let us see the impugned order once.
मतलब would you lordship take it day after tomorrow मतलब for hearing?
Affidavit in reply filed in court today be kept with the records. Paragraph on the request of learned advocate for the appellant, comma, list this matter once again on Purshudine Tariq diye daw.
I'm so grateful. Good, 100%.
Number 8. May I please, your lordships? My lord,
I
this
have
is
for the response.
my appeal, my lord. My lord, this emanates, my lord, out of my lord rejection of my Order 39 Rule 1 and 2, my lord, arising of a copyright matter. My lord, in short, my lord, the matter this pertains to, my lord, we are Indian Performing Rights Society Limited, my lord, which is, my lord, formed under the Copyright Act itself. My lord, I'll take your lordships to the provision. My learned friend's client, my lord, they run a hotel.
1 second. 1 second. What happened to the CO 130?
My lord, no steps taken, my lord, it is pending, my lord. My suit today is as on board. So, my lord, there is no impediment, my lord, in moving this, my lord.
Very well.
And, my lord, I had indicated also on last occasion, my lord, the CO itself was filed, my lord. My lord, it should have been filed before the IP division, my lord. But it was not, my lord. So, whatever be the fate of that, my lord, will be decided later on. So, my lord, this, my lord, matter pertains to, my lord, my client is Indian Performing Rights Society Limited, my lord. I am, my lord, constituted under the statute itself, under the Copyright Act. My lord, I look after, my lord, the rights of around 16,000 author composers.
Not Companies Act.
No, my lord. I'll my lord, indicate, my lord. Around 16,000 author composers all over India, their rights are administered by us. And, my lord, under the statute, my lord, a license is issued to us that we only can do that. My learned friend's client, my lord, they run a hotel by the name of Hotel Apollo. So, my lord, what they do is, my lord, they have TV sets in their rooms. My lord, in those TV sets, my lord, they obviously, my lord, also use, my lord, repertoire which belongs to, my lord, our clients, literary and musical works. Any songs.
All hotels do that?
All hotels do that. And, my lord, all take licenses also.
From you?
From me for doing so. This is one hotel, my lord. This issue has been, my lord, also, my lord, it's been an old issue, my lord. It has been challenged, my lord. I have a judgment also with, my lord, Mr. Bachawat, my lord. My lord, kindly grants him.
Very short point and an interesting issue. Lord, keeps coming back. Lord, I'm surprised at not where music has gone and how much it earns nowadays. But earlier, your lordship will remember, Lord, composers getting rid of their rights, Lord, at for 500 rupees for 8 songs for a film. Lord, 1960s, 70s, all the famous Lord composers. No one expected it bring so much royalty. But then Lord FM radio came and Lord money started pouring in. And then Lord thereafter your lordship has seen cable TV, all of these. There are multiple rights. Now Lord the fundamental
Before
thing,
you proceed, Mr.
Yes.
Bachawat, I must tell you,
Yes.
money and music. When I was in college, I used to earn a quick buck. I used to be hired. I used to be taken to overcrowded places to sing so that the crowd will disperse, run away.
My Lord, your lordship has grabbed the words of my wife. She sings well. She has classical training, and there are places where, or there are invitations where, well, one half of the couple has to be a singer. So they encourage the other half to also become a singer over time, and all their efforts to make me one not has failed. I am the only one of not a group of 50 people. If I sing, everyone wants to go home. Not that's the situation.
Yes.
So now, Lord, with music, not what happens is, Lord, we are used to seeing, let's say, a record or a LP or a CD, and we hear the music. We think, Lord, it's the sound recording as a whole in which the light rise. But Lord, the law is this: there are separate rights within the song one hears. So, Lord, the lyricist has a right, the composer has a right, the recording company has a right, and everyone has a right to a share in the royalties. That's the established law now, Lord, over time. Although there's a composite one thing that one hears, not everyone had a right except for the singer. Perhaps not for the singer, it's because of him songs become hits, but the song did not, the singer never had rights at all. Now, Milord, the Copyright Act has been changed to also give them rights. I'm not advocating their rights over here. So now, Milord, amongst these multiple rights are what's the lyrics and the music.
We are hearing out the appeal?
Yes, your lordship will do that.
All
But,
papers are
it'll be-
before us?
Yes.
But, Lord, I need to use an affidavit, Lord. It's coming for the first time.
Before
all affidavits from the trial court.
before the trial court, you didn't file affidavit?
Yes, he did.
It is
He
there.
He
They are
did.
pressing for an injunction here before your lordship. If your
Yes.
lordship desires to hear the appeal, Lord, let them, Lord, make their submission today. Grant me 1 day time, I can reply.
Very,
The point is very short.
Yes,
that,
yes.
that, that's
all
the point is short.
Point is short.
Point is short. So now, my lord, like I said, my lord, there are multiple rights. So, my lord, the rights of the lyricist and the composer are what a society called IPRS represents. So, my lord, all lyricists and composers have given their rights because it's not possible for them to track which radio station is playing which song for how many minutes of royalty payable. So, they have given it to a society known as IPRS. Now,
As a matter of interest, who fixes the rate of royalty?
So, my lord, there are 3 or 4 ways. I'll just tell your lordship that also. So, my lord, the rule is the owner of the work has the right to decide what he's going to pay, or what he wants to be paid. So, it could be anything, 1 rupee or 15 lakhs. It's up to me as the owner of a property. I decide how much to let it out for. Let's put it not in terms of property. It is for me to decide. Now, thereafter, my lord, there is a body above that called the Copyright Board. So, if there is a dispute relating to these things, then that body decides that dispute. Now, there is a third thing also, my lord, there are various methods. So, my lord, let's say I will not give it to anyone to use unless they pay me 20 million. Someone can come up and say, look, that is preventing this work, whatever the work be, from being disseminated to the public, and apply for what is called a compulsory license. So, a compulsory license can also be given. Then again, Lord, there are scales of rates fixed in relation to copyright societies, so that not a uniform amount is charged. Not I can't charge, let's say, Mr. Rai Chaudhary 5 rupees and charge Mr. Tilak Bose 500, even though he can afford to pay. Then there are rates for bulk users. So, Lord, rates have been fixed. Lord, it's known as the tariff for these copyright societies. So, those tariffs are fixed. So, now, Lord, based on that, the copyright society collects on behalf of the lyricists and composers. And that is then, Lord, again distributed amongst the lyricists and composers. Now, Lord, this right, Lord, now, Lord, to go back again one step, Lord. So, therefore, what is a right? Not the copyright. It's not put very simply, it is a right to exploit the work myself or to permit someone else to exploit it. In other words, without my license, no one can not use it or exploit it. This is not the long and short of it. I'll show your lordship the section. Now, in this case, not what is happening is, now, before I go to this particular case, so the law which has grown now, it's well established law. If, for example, I am to play it at a function. I am having a party, there's a function, or let's say the function where someone is coming and performing it. The moment they use a work, irrespective of which one it is, royalty becomes payable to someone or to multiple people. So, to give your lordship an example, if a song is being played, one royalty would be payable to a society called PPL, which is Phonographic Performance Limited, which collects on behalf of the recording companies. So, one royalty becomes payable to them. A separate royalty is not payable to the lyricist and composer also. So, another royalty becomes payable to IPRS, which collects on their behalf. Similarly, nowadays, singers are entitled to it. So, for the same work being played, separate royalties will have to be paid by each of them. This is the, let's put it, fundamental thing behind it. Now, this is payable irrespective of not whether it is being broadcast over TV or in a auditorium, anywhere other than perhaps a private home. There is an exception made. So, therefore, when your lordship is watching it at home, privately, then nothing needs to be paid to anyone. So, it's in this background now, your lordship looks at it. There are hotels. These hotels are offering a service to their customer for which they charge. For example, a hotel with a swimming pool is going to charge more than a hotel without a swimming pool. So, depending on the facilities that they have, they charge higher amounts and they are somehow reimbursed or they are taking in the cost. Now, you may provide a TV, you may not provide a connection to anything, not necessary anymore, because not all of our phones nowadays have streaming. So all that one needs to do is from one's phone, one can just play it on the TV. But in this case, what is happening is, my lord, hotels are having a set-top box by which, my lord, they are able to provide anything or nothing to their customers. So in some hotels, your lordship will find one can keep flipping channels and get nothing. There will be a logo for Netflix, but one won't get it. Now, in this case, they are providing channels through which music is being played. Now, we have our rates of tariffs for hotels, number of TVs, number of rooms, all of that put together to arrive at a tariff. So, my lord, this tariff is circulated, hotels pay it. Now, this particular hotel in this case has refused to pay it. So, my lord, we applied for interim orders. My lord, interim orders have been refused, my lord, on some basis which I have actually not followed. I'll show that to your lordship. And, my lord, we've come up in challenge against that order. And the law in this regard, my lord, there's a judgment, my lord, on identical facts, which we have, which I'll show your lordship, and it goes back to 2009.
Calcutta, Calcutta.
No, it's a Delhi. My lord, your lordship will find most of the judgments relating to copyright, my lord, or particularly with regard to broadcast and other things, are now Delhi. Because I'll give you a lordship the history a little bit. But lyrics and music was never the subject matter of litigation for a very simple reason. But a lyricist or composer, he was approached by the director or producer of a film, told, look, I need 4 romantic songs, I need 5 songs, sad songs, and maybe 2 joyous songs. And please give me a tune. So a tune would be made. In exchange, he was given 4,000, 5,000 rupees. I've seen those receipts. And he assumed that his right was at an end. Now, those songs became hits. No one saw that over time, these would be money spinners because FM radio will come. Thereafter, cable TV, broadcast. No one had foreseen it. So, at that point of time, nothing. So, their rights were completely forgotten. Then, with FM radio coming in, this suddenly became a gold mine. Everyone started collecting royalty, and now, fortunately, lyricists and composers' rights are also protected. But it's only after this electronic revolution that these have become a gold mine. Earlier, no one would have thought of paying a composer for a remake right, because everyone assumed that the film producer was the owner of that right.
A lyricist or composer will have to become your member.
Yes.
Member.
They're all members.
All members.
They authorize me to collect on their behalf. So all lyricist composers largely are members of this. And these are statutorily recognized societies. There's a section under the Copyright Act. They have to be given recognition by the government. They have to file accounts, detailed accounts of the manner of what is collected, what is paid out, and all of that. So there's been much litigation relating to that also. So this is the situation. Now, in this backdrop, again, section. But before I take your lordship to the order, could I do something? Could I just show your lordship 2 or 3 basic sections?
Yes, please. Copyright Act.
Yes.
আছে কিছুই তো নেই আমাদের কোর্টে।
But I believe there, otherwise we have copies. So first, my lord, what is the right? The lordship would but if I could take your lordship first to section 13.
Yes. 13.
Yes, ma'am. Not just very briefly, Lord. 13, works in which copyright subsists. Subject to the provisions of the section and other provisions, copyright shall subsist throughout India in the following classes of works. So now, my lord, if your lordship sees, these are independent copyrights. A, original literary, dramatic, musical, and artistic works. So, my lord, the literary work would be the lyrics. The musical work would be, my lord, the music of. And then your lordship will find there's an independent right in the cinema. So, my lord, if the song goes into a cinema, there's an independent right in the owner of the cinema, in other words, usually the producer. And lastly, your lordship will find there's also independent right in the recording company. Sound recording also has an independent copyright. So, my lord, this is just to illustrate, my lord, what can be the subject of copyright. Then, my lord, if your lordship takes, my lord, 13.4. So, my lord, the fact that it has gone and merged in a film doesn't affect the right of the musician or the lyricist. 13.4, copyright in a cinematographic film or a sound recording shall not affect the separate copyright in any work in respect of which a substantial part of which the film, or as the case may be, sound recording is made. So, my lord, it can't be said that the lyricist or the composer loses his right the moment it has gone into a sound recording or a film. Each of them have their own separate rights. And this, your lordship will find, that came in by way of an amendment years ago, perhaps 1994. Till then, Lord, now what I apologize. So, Lord, till then, Lord, there was a lot of litigation and there was confusion. So, this cleared up the confusion that separate copyrights are not destroyed by the fact that they've merged into a larger work. Then, my lord, if your lordship comes to 14. Or before that, not since I've shown your lordship 13, if your lordship just comes to the definitions once. Now, your lordship has seen the use of the word works in section 13. Now, that is defined in 2y. It's the same thing, but it's there in the definition. So, work means literary, dramatic, musical, artistic work. Now, my lord, from here, if your lordship would come to 14. So, Lord, copyright can exist in these works. Now, what does this having a copyright give you? That's 14. 14. For the purpose of this act, copyright means the exclusive right, subject to the provisions of this act, to do or authorize the doing of any of the following acts in respect of a work or a substantial part thereof. So, it's the exclusive right to do the following. Now, my lord, in our case, I won't trouble your lordship. It's a very long section. But if your lordship sees 14A2, 3. To perform the work in public or to communicate it to the public. So, this is where this would really fall. And yes, Lord, if your lordship then sees the definition of communication to the public, Lord, if your lordship comes to section 2FF. Now, this will be of some importance over here. There are two other definitions which will be important here, which I'll bring your lordship to. Now, Lord, 2FF, communication to the public means making any work or performance available for being seen or heard or otherwise enjoyed by the public directly or by any means of display or diffusion other than by issuing physical copies of it, whether simultaneously or at places and times chosen individually, regardless of whether any member of the public actually sees, hears, or otherwise enjoys the work or performance so made available. So, my lord, in other words, making it available is good enough. Whether someone not actually switches on his TV or not, or watches a particular content or not, is not the point. And Lord, please see the explanation. For the purpose of this clause, communication through satellite or cable or any other means of simultaneous communication to more than one household or place of residence, including residential rooms of any hotel or hostel, shall be deemed to be communication to the public. So, Lord, I'm covered fully now. Now, their argument broadly seems to be, or I'll take your lordship to the definition first. Now, my lord, please come to 2DD. their case, although not the learned judge has mixed things up a little, but is not that this is a communication to the public, but this is a broadcast in which not these rights have been given up, that is 2DD. Broadcast means communication to the public by any means of wireless diffusion, whether in any one or more of the forms of signs, sounds, visual images, or by wire. Now, this, my lord, this definition is there because of not section 37. Now, please come to section 37. Now, I am not claiming to be a broadcasting organization. Please remember this. So these, Lord, don't apply at all. Section 37, Lord, if your lordships have got it, I'll just place it very quickly. Every broadcasting organization shall have special rights to be known as broadcast reproduction rights in respect of its broadcast. The broadcast reproduction right shall subsist until 25 years, etc. And then, Lord, during the continuance of broadcast reproduction right in relation to any broadcast, any person who without the license or owner of the right does any of the following, which is not rebroadcast the right or cause the broadcast to be heard or seen by the public, etc. Now, and not that your lordship will find is a infringement. Now, Lord, I tell your lordship basically what the difference in principle is. Lord, let us say, Lord, I'll take an example. I am a studio in a not of a broadcasting organization. Let's take something like NDTV. Now, NDTV has its own studio. Not I am, let's say, a news broadcaster, which I'm not. Not there are many perks which come with the job. But let's say, not I was one of the well-known anchors. Now, when that show is being made and that is being broadcast, that is the broadcaster's right. So he has a separate broadcast right or a copyright in what is being broadcast by him. That has little to do with not these songs or any other thing not on which we are claiming. I'm not claiming to be a broadcaster. But I haven't seen how this comes into the picture, but it has been brought in. Now, Lord, right from here, Lord, I'll just give your lordship the facts in 2 sentences because it's really not really a question of law. So, Lord, I think I managed to switch it off. No, it's there. Now, Lord, facts are very simply this. My learned friend has a hotel. The hotel has got set-top boxes and TVs. One of our representatives went over there, switched it on, saw that these songs are available. He played them. He's given a list of all the songs which he heard during that time. So one could call it a trap. One may not call it a trap. It doesn't matter. Fact is that these are available on his set-top box and it's not disputed by him. Now the question is, Lord, can he do so? I have told him take a license. He has refused to do it. Now the point is, can he play this or offer it without, my lord, getting a license from me? This is the short question before your lordship. Now from here, my lord, there is no other fact to be gone into at all. From here, I show your lordship the impugned order and one judgment I'll rely on.
No. Yes. Where in the statute are you recognized?
Oh, I see. I'm sorry. Not please
that
come
is
to
important.
Section. Yes, I'm sorry. 33. So, now this whole chapter, chapter 7, is dedicated to copyright societies. Registration of copyright society.
Chapter?
Not chapter 7. Entirety of chapter 7 is to do with copyright society.
Right, right.
Now, let's see how broad these powers are. No person or association of persons shall, after coming into force of the Copyright Amendment Act 94, commence or carrying on business of issuing or granting license in respect of any work in which copyright subsists or in respect of other rights conferred by this Act, except under or in accordance with registration granted. So, my lord, unless one is registered, one can't do the job of collecting. Now, for example, my lord, PPL is the body which is registered for collecting on behalf of the sound recording companies. Similarly, IPRS, who I represent, are licensed to collect on behalf of lyricists and composers. PPL is gone. Okay. PPL was, I stand corrected. Mr. Roy Chaudhary is actually much more up to date on these matters than me. But PPL, well, from our times onwards, was always registered. Then, disputes arose with regard to the management of both IPRS, PPL, etc. There was litigation. The Copyright Act was amended because PPL was actually impinging on the rights of IPRS, because the sound recording companies became members of IPRS. And the act had to be changed. There's a lot of backstory behind it. But ultimately, PPL came to be derecognized. And they are awaiting further registration. So this is the situation as far as that's concerned. Now, then, if your lordship sees subsection 2, I won't bother your lordship with the provisos. Any association of persons who fulfill such conditions as may be prescribed may apply for permission to do the business specified in subsection 1 to the Register of Copyrights, etc. And then, central government will also have to approve it. So it goes through a longish process. And we are registered. That certificate is annexed to page 100. Our certificate of registration is also annexed. Page 100. If your lordship sees that or makes a note. So the government of India has given a certificate of registration. Then, my lord, your lordship will find the interesting thing here is there can't be two copyright societies for the same kind of thing. That is, if your lordship sees subsection 3. Subsection 3, please see the proviso. I'm not bothering your lordship with the details. Provided that the central government shall not ordinarily register more than one copyright society to do respect in respect of the same class over. So it's like a monopoly in a sense. And so on and so forth. Then 33A, your lordship will just look at the headings only. There's a tariff scheme. So copyright societies can have a tariff scheme. And anyone who is unhappy with it may appeal to the Copyright Board. Which is what I told your lordship in the beginning. And the rest of it, the manner in which it is administered, payments made, all statutorily governed. And like I told your lordship, under 36, all these returns have to be filed with details. So, your lordship has seen chapter 7, therefore, relates to copyright societies. Chapter 8 relates to broadcasting organization.
Payment of remuneration by the society, that was deleted. 34A.
Yes. Yes. But it must have been subsumed within some other subsection, I suppose. Or, the rules. Obviously, people who are working for the society will get paid. It's gone into the tariff scheme. But please give me a moment, since it's fallen from your lordship, Mr. Roy Chaudhary points out that it's there in the rules. No, not the tariff. He's talking about remuneration. Remuneration has been. The provision for remuneration is gone.
Remuneration to whom?
People working there,
Working there, not to the composers or.
No, they are they will get a share of it. That's the please see the section itself.
Remuneration payable to individual copyright owners.
Oh, I see. This was Indian. I see.
That is why that is clear.
Oh, I see. But please give me a moment. Your lordship has put a question. Let me be not 100% sure before I. Yes, that section is perhaps gone because a 33A has come in. Now, please see 33A.
Mr. Bachawat, we need to stop today. There's a matter fixed at 12:30. Our learned counsel for the 12:30 matter here. Your matter, Mr. Bag. Will you do it? You'll do it.
That matter, I made submission from my learned friend, Mr. Shoturu Banerjee will make submission.
Oh, that section
12.5.
12.5, 7th schedule.
7th schedule.
Where's Mr. Banerjee? Unless he is here,
I just saw him outside, not he's there.
let's see if he's available. We'll stop then.
Yes, but till then, not I'm
Yes,
just taking
yes,
your lordship through
yes.
the act, not
Yes.
33A, if your lordship sees.
Yes.
So, your lordship is right, not that dealt not with the remuneration payable to staff working there. It dealt to, not really speaking, the royalty.
Yes.
But not that's replaced by 33 capital A, which your lordship will find also came in 2012. So now, not it's under a tariff scheme.
This tariff has to be paid to the society by somebody who wants to play a
The manner of distribution is also provided.
manner of distribution. It's all very interesting. I mean, it's very new to me.
It is. But well, for me, it was a lot of fun because, not strangely, a lot of this began from our High Court. Your lordship, if your lordship looks at it, the two earliest well-known judgments are out of Calcutta High Court to do with not IPRS, 1978 Calcutta. Then that went up to the Supreme Court. So there's a judgment. Then there's a second judgment. So that was one chapter. But there the question involved was very interesting. Not like I said, not the at that time the separate rights were not recognized by in specific words. So confusion arose that look, once something goes into a film, a song is sung, blood. There's a lyricist, there's a composer, there are musicians, there's a band, there's a singer. Then the recording company not records it. It goes into a film. Now, who has the right over the not this music, which is now in the film? So, Mlad, after a lot of litigation, it came to be held that, well, the owner of the film has the right to play it fully, but only when it is fully part of a film in a cinema hall. He does not have any other right. So, therefore, Mlad, the rights of the sound recording company to issue cassettes now becomes clearer. But it left foggy the question of what happens to the lyricist's right. Now, under Section 14, Mlad, they have the exclusive right. Now, Supreme Court left a few odd lines in that judgment from which it was unclear about who had to prove whether the right had been assigned by the lyricist or not assigned. Now, you can't show the negative. So, not the lyricists and the composers could never show that they have not assigned the rights. So, not the music companies, the recording companies continued to act as if they were the owner of the lyrics and the music. And a lot of interesting litigation happened, Blood, which came to the fore once FM radio came in. Now, as far as that was concerned, at that point of time, there were no rates. Akashvani was the only radio station. But the rate of tariff was something like 5 rupees per needle hour. So, needle hour meant when the gramophone is playing, if the needle is down on the record, if it's down for 2 minutes, that's part of a needle hour. So, they would count it and it would be 50 rupees a needle hour. Now, when the private radio companies came in, these societies started demanding 1500 per music hour. So they said this is discriminatory and there were challenges before the Bombay High Court. So the Bombay High Court said, no, you deposited 1700 a music hour. That's when some radio stations first came to Calcutta, and that's how Calcutta got a good history of a good innings of FM broadcasts, flocking to Calcutta because Calcutta said 500 rupees per music hour you put in for the time being.
You will come back day after tomorrow? Hey, Shonu.
I don't know what I asked.
মঙ্গলবার প্রথম তো নন কমার্শিয়াল হবে তাই তো নন
দিয়ে দিচ্ছি আমি জাজ not I'll give my learned friend the judgment I'm relying on.
So that Lord, I can be
Yes.
prepared and not keep my reply.
দিয়ে দিচ্ছি চমৎ দিয়ে একটা কপি আছে দিয়ে দাও
আর কিছু বলার আছে বেসিক্যালি না এটাই
You see, Mr. Bachawat, on Thursday, we will start with non-commercial. We'll first only take the applications and then we'll take up this commercial hearing. We want to complete this.
Lord, I would have loved to. Lord, only thing is I'll be on legs in that South Point matter on Thursday. I'm not sure at what time. Your Lordship keeps
We'll
it. Lord.
see.
If there's some, yes,
We'll see. Hey, Lekho. And Mr. Bachawat, learned senior counsel representing the appellant,
copy this.
begins his argument but does not conclude. Paragraph as requested by learned counsel, list this matter once again on Thursday date the Porshuddin date the. So this will be the first hearing matter effectively. Later now.
Item number 16, 436 matter.
Please, Your Lordships, I am appearing for the appellant in the matter. Meet my submissions, please.
Remember that you have completed.
We've completed, my lord. Only on the 12-5 issue, my lord.
Only 12-5 issue.
My lord, I have a very small issue with regard to, my lord, this matter, because, my lord, as far as what my learned friend has argued, that is a correct proposition of law. There is no doubt about it, post the amendment. But, my lord, kindly sees his pleadings, why this proposition of law will not apply to this. Kindly comes to page 16 of his paper book, my lord. Paper book, volume 1.
You note photo chain ki na?
16.
ये तो खाली judgment बोले गया था. Wait, actually.
The sentence starts with that thereafter. And that thereafter in a most mechanical manner.
What is this? What are you reading? What
I am
is this?
reading his petition itself, mother, which is part of the paper book, mother.
34 petition.
Known pleadings before the trial. May I, my lord, read? And in a draconian exercise of executive power, arbitrarily the railway issued a 48 hours notice to the claimant on 14/11/2011, following which the notice in lieu of termination dated 18/11/2011 was issued. Simultaneous, the bank guarantee and EMD furnished by the claimant to the tune of rupees such and such and such and such respectively was forfeited. The claimant raised their objection to the termination notice by its letter dated such and such, but none of the respondents' representations of the claimant were considered, following which, this is very important, kindly mark, petitioner was forced to invoke the arbitration clause and request for appointment of arbitrator, and thereafter by a dint of the letter dated, kindly mark this, my lord, 16/8/2012, the arbitral tribunal was constituted. So this is pre-amendment. This is pre-amendment. This is his own pleading. It's constituted, my lord, in 2012. Initially, with Sri such and such, such and such, such and such. The learned tribunal was reconstituted with the present arbitrators. So therefore, my lord, reconstitution is not the same as constitution. Reconstitution is a continuation of something which is being constituted already. It's not afresh. And that is the catch, my lord, here. It's from 2012 because the language lordship sees in section 16 from the date it is constituted, and the pleadings also says it's constituted in 2012. So therefore, my lord, the moment there is a, my lord, things of
Why was such reconstitution necessary?
because, my lord, I think there were certain, my lord, difficulties with the arbitrators. I wasn't part of the arbitration proceedings, so I can't. But I think that is the reason, not because of the amendment or something like that.
Page 273, my lord, the second paragraph. That's the reasoning, my lord, and that is where, my lord, it is indicated 2016, it was entered into, the reference was initiated. My lord, that's page 273, paragraph
So that's the
1.1.
second after reconstitution, but lordship has to see it from 2012. I am not even, my lord, saying that it's not been reconstituted post, my lord, the amendment.
Mr. Banerjee, in 2012, there was no such bar, let us say, the bar which the amendment brought in. Now, the person whom you appointed for whatever reason could not act as arbitrator.
Not all. Here are three, maybe one or two.
Very well, one.
But they entered upon the reference, my lord. That's the issue.
You had to replace that person.
Maybe, my lord, I wasn't there, my lord.
Had to. So this gentleman.
Must be. So it was reconstituted.
If on that date there is a bar, that will not hit you.
No, because, my lord, this is reconstitution, my lord. It is not constitution. This is the, my lord, thin line which lordship has to consider.
Very well. We have followed your point.
So therefore, my lord, apropos this, when there is a I'll give an example, my lord. My lord, let us take, my lord, that there is, my lord, an appointment which has taken place, and, my lord, a section 14 issue is raised before the arbitrator of, my lord, a constituted, my lord, arbitral tribunal which has been done prior amendment. And I take, my lord, the point of section 14. The arbitral tribunal, my lord, does not pass an order. I come up in appeal. Court feels that it is so, and, my lord, sets aside. Now, my lord, will that lead to, my lord, the arbitral proceeding being, my lord, started post amendment? I can't take advantage, my lord, of the amendment then, saying that, my lord, that this cannot happen because the amendment has come in. The constituted arbitral tribunal would be from the date it has been constituted. That is, my lord, kindly sees the language, my lord, on the day that they enter the reference. And there is no dispute, even if I go to that page, my lord, that they entered the reference sometime in 2012. But kindly takes section 21 once. Commencement of arbitral proceedings. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Here, my lord, I am the respondent. I am not quarreling that it was in 2012. And that's his pleading also. So commencement, the language is very clear, is from the date, my lord, he gives me a notice and I receive it. And here I have a better case. Even he pleads that it is 16/8/2012. So once the tribunal is commenced or, my lord, enters reference, that is pre-amendment, admittedly. And reconstitution, my lord, is, my lord, only, my lord, what is there. It's, my lord, only forming something in a different way. But the way, my lord, has already been established. That is why we cannot take an advantage, my lord, in a section 14 or 15 proceeding before my lord in an arbitral proceeding which has taken place or been constituted or referred to prior to 2015. 21 language, my lord, kindly sees is very clear. Unless otherwise agreed by the parties. I did not agree to anything else, my lord. The arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. So I don't have to look into even, my lord, when they enter upon reference.
No. This bar is on the particular person, ineligibility of the person.
Correct. I'm so grateful.
So therefore, at what stage is irrelevant?
So therefore, my lord, kindly sees it is in 2012.
Constitution or reconstitution?
But it is because, my lord, of the judgment of BCCI, where it says, my lord, it is prospective, not retrospective.
No, it may have commenced in 2012. Doesn't matter.
But then, my lord,
But if you're the second person is again appointed after the bar comes in, he's ineligible. He was.
But my lord, not in this case. Lordship has to consider this, not in this case.
Very well, we followed your point. Anything else?
This is the only point I want to argue, my lord, and I want to test, my lord, because, my lord,
You're arguing.
This is exactly what I'm saying, my lord. This is, my lord, a case. Otherwise, it's a very, my lord, simple case, my lord, where, my lord, unilateral appointment will come into force.
Ineligibility of a person.
পেজটা কত বললি তুই? পেজটা কত বললি? না 270। ঠিক আছে, ওটা দেখছি না, অন্য
Substitute, right? Not future.
My Lordship will not take me amiss. My Lord, I'm just trying to, my Lord, expand on this more. My Lord, let us assume, my Lord, a proceeding is constituted prior to the amendment of 2015. I file a, my Lord, 1415 application sometime in, my Lord, 2017. Lordship considers de jure de facto 14 read with 15, which gives me a right for substituted arbitrators, and appoint somebody. Let us take, my Lord. And I come to know, my Lord, that, my Lord, he has got some interest with, my Lord, the proceedings which are, my Lord, referred to him. My Lord, in that case, it would open a floodgate. I would be entitled then, my Lord, to file, my Lord, an application for removal under the new amendment. That can't be, my Lord. That is not perhaps the intention of the legislature, because that is why, my Lord, the judgment in BCCI says from paragraph 36 onwards that, my Lord, proceedings which have initiated earlier cannot have the advantage of the amendment any further. It is not retrospective.
Amendment of subsection 5 of section
Yes,
12.
any amendment post 2015. It's all.
No, does it specifically refer to this?
It says the amendment.
And what amendment was it considering in that case?
In that case, the amendment said, Lordship, in 2015, the entire
Mr. Banerjee, what's troubling me personally, at least, the object must be that the rule of nemo juris non sua causa is not flouted.
I agree with my Lord.
So therefore, at any given point of time, if the legislature makes it the law that these people will be ineligible because otherwise he will be the judge in his own cause,
Correct, my Lord. Correct, my Lord.
that has to be given full effect.
But not to our proceeding which has been initiated earlier than the amendment.
Why not? If
Because
the decision is still pending,
because
why not?
unless, my Lord, the act itself says so in the amendment itself that the amending act would have a retrospective effect and not a prospective effect. My Lord, that is the rule.
That we understand somebody appointed prior to the amendment, the arbitration
takes place, my Lord.
very well. The arbitration continues, spills over beyond the amendment, right? So this, although this gentleman was eligible, becomes ineligible as per amendment, because as you say, prospective may not apply. But when the second appointment, call it substitution, call it replacement, call it reconstitution, when this is done post-amendment, then why shouldn't that?
This is, my Lord, reconstitution. Exactly, that is what I'm saying, my Lord. I file a section 14.
What is the magic
before my Lord?
What is the magic in that word? Object. What is the object? That is the most important thing.
The object is that, my Lord, a constituted arbitral tribunal has already, my Lord, cast upon certain, my Lord, proceedings and, my Lord, taken certain decisions. Maybe not in this case or in the other case. Then the entirety will go.
No, why? Any event you have to appoint somebody.
No, my Lord, this.
Why don't appoint somebody?
This, my Lord,
doesn't flout that.
My Lord, kindly
part.
says this, my Lord, kindly
Also,
will
there's
not
no
happen.
If you have a choice of appointing somebody which will not flout subsection 5, appointment has to be done.
Yes.
Constitution, let's not play with words.
Yes,
somebody will have to be appointed because the earlier gentleman could not act, resigned, could not act, whatever the reason. So if there is a choice of appointing somebody who has no connection with the railways and somebody who has a connection, why should you appoint somebody who has a connection?
Because, my Lord, the simple reason is that, my Lord, the Lordship has to see when, my Lord, it has come into effect. That's, my Lord, the most important part. Otherwise, all matters. Then I will have a right to come before my Lord, which were pending. And, my Lord, say No, I'm saying pending matters which were there. In all pending matters, my Lord, where the award has been passed, my Lord, post-amendment, then that right would accrue in favor of each of the, my Lord, claimant or the respondent, whoever has suffered the award.
No, possibly not. Anyway.
So therefore, my Lord, I say that this could be a situation before the court also, under 14 and 15, because it's de jure de facto. I can come up before my Lord. In a proceeding, my lord, kindly sees in 14 and 15, I'll show it. I can take this point only in a pending arbitration proceeding prior to amendment and ask my lord to remove the person. Because it's de jure de facto. I qualify for both. This would open a then floodgate. Kindly sees, my lord, section 14 and 15 once. Lordships only have got the right, my lord. Kindly take section 14 after 21. Kindly take section 14. Failure or impossibility to act. The mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes de jure or de facto unable to perform his functions. To my lord, I qualify then, even if it is an appointment pre-amendment, to come before my lord under my lord de jure and ask for a substituted arbitrator under section 15. Read with 14. And this can happen with every arbitration proceeding which was pending prior to the amendment. Unable to perform his functions or for other reasons, the amendment gives me the right. He should not be performing, my lord. He's barred by law. And lordship, if lordship holds in my favor under 14, 15 gives my lords to right to my lord replace him. Termination of mandate and substitution of an arbitrator.
When would one de jure become unable to perform? না সেটা তো অসুস্থ এমন হয়ে গেল the law. Why is not subsection 5 such a law?
I'll be grateful, my lord, if this is followed, because I'll file applications there.
Correct.
Actually.
Me. It may not unsettle যেটা বলতে চাই এটা ব্যালেন্সড হবে যে যে অ্যাপয়েন্টেড হয়ে গেছে even if the arbitration spills over
हाँ यही ना
he wants to participate in our discussion.
चलो यार
কোত্থেকে আসছে এটা Mr. Banerjee, please. At this point, it's debatable. We have to think about it. It's not an open and shut case.
I come back in that case.
No, you have 10 minutes more.
No, I'm not saying that, my lord. If lordship wants some more.
No. After hearing you all, we'll sit over a cup of tea, two of us. We'll discuss.
Then, my lord, I can, my lord, put some more, my lord, issues before my lord with regard to 14 and 15 circumstances, my lord. There are judgments also to that extent.
Do you require some more time? Then we'll give you.
Your lordship, my lord, is, my lord, to consider this situation.
Yes.
Lordship says, then I apart from BCCI, I'll show judgments on 14 and 15 because BCCI was very clear. It's prospective, can't be retrospective to any proceeding. But there are judgments of this court also, although single bench, dealt very nicely of Justice Shroff also, then I'll bring them. They're on 14 and 15 situation.
But perhaps that will not be required if I show one document. In fact, two documents. Will kindly take up. I'm sorry, I'll just show two documents. Page 273, the first paragraph and 1.1, and two paragraphs of a minutes of the meeting. This amendment was considered, and the parties were requested and given time of 30 days that if you give a written consent, that consent was never given by us. I'll show that from the minutes. It is conceded by them.
273.
73, the award starts from 272.
Yes.
272 it starts. At 273, kindly take up the first paragraph and paragraph 1.1.
Yes.
Acting through the assistant engineer, the first line, Southeastern Railway, Jharsuguda, Orissa, out of this, the undersigned so-and-so, the then chief motive power engineer, Southeastern Railway, Garden Reach, and now chief workshop engineer, has been nominated to act as presiding arbitrator, and so-and-so, the then so-and-so, the designations are given as co-arbitrators by General Manager, Southeastern Railway, by letter dated 18/4/2016 for adjudicating the claims and disputes arising out of the said LOA and published the award. Then paragraph 1.1, and whereas the arbitral tribunal consisting of so-and-so and others as above entered the reference with both the parties on 30/12/2016. That's first, Now kindly with this, take up the minutes at page 259. Page 259, volume 2. Kindly see the top, minutes of the first meeting. So this is after reconstitution, First meeting, page 259, held on 2nd of May 2017 in the chamber of so-and-so. The date is important,
Yes.
Please take the first paragraph, A letter along with pro forma regarding consent for switching over to the Arbitration and Conciliation Amendment Act 2015 was handed over to the claimant and the respondent, advising to submit their willingness or consent in the enclosed pro forma within 30 days from the date. Now, this was never given,
By you.
This was never given by us. Then paragraph 2, since the presiding arbitrator and one of the co-arbitrators are completely new on this case, the respondent were asked to elaborate the contractual obligations and then the matter continues.
But this is to
So
my
they were-
advantage.
they were-
I am grateful to my learned.
This is not to his advantage if this is not given. We have never given this. So, since we have never given this, they concede that the amendment will apply.
They have not considered.
It only goes a step further to assist us. That's my submission.
It helps me, my lord. I'll then, my lord, elaborate on this.
Appointment is too bad. It's a post-amendment appointment. Right. Because it is badly realized. Please give your consent. If you give your consent, we can continue.
16 করেছিস করিসনি তো
নিউ তো হ্যাঁ তো বাড়ির পরে তো এরা অ্যাপয়েন্টেড হয়েছে কি করে হয় entered in reference তো এখানে বলছে entered upon reference on 30/12/26 যাই হোক থাকে এখানে তো বলছে 30 tribunal entered upon reference on 30/12/2016 You better come back some other day.
This is even better for me.
No, it's better for me, my lord. I'll indicate why.
You decide that who it is better for.
Because here it indicates that they, my lord,
With my little assistance from the Union of India, I'm grateful to my learned friend for showing this.
this I'll indicate, my lord, why this is helpful for us. My lord, the option was then recognized that the amendment will apply, and we were called on, my lord, to give this consent, which we have not given. If we have not given in writing, my lord, which we have I've taken clear instructions, we've never given it.
Yes.
So now we have taken this point, my lord, that they didn't have jurisdiction, my lord, to continue with the matter.
না না আজকে নেমে ও কফি খেয়ে এখন আলোচনা করবে পয়েন্টটা।
মান্ডে বাদ দাও। Tuesday, next Tuesday, 12:30 by 5th.
অন্য ম্যাটারটা ওদিনকে ফিফথ আই এম নট দেয়ার, সরি এনি আদার ডে, ফিফথ
7th, দেখো 7th দেখো, 7th August.
Lordship allows me, my lord, although Lordship allows certain single judges bench judgment also.
No,
Very
of
elaborate,
course.
but my lord,
Adopt
maybe
it
not
as part.
binding on my lord, but the
You can always adopt it as part of your argument. That's what we have done always.
so that is my lord kindly allows me, my lord. Please.
Yes.
But there is a very good judgment of this honorable court, although my lord is no longer a judge of this court anymore, but then my lord very elaborately discussed with the point of voting.
Your order to the last order to the
Seventh. হ্যাঁ
Mr. Banerjee, learned counsel representing the respondent begins his argument but does not conclude. Paragraph lists the matter once again. Date thou, August 7, marked 12:30.
Great.
45 minutes.
Enough, my lord.
Enough for both of you.
I'll take 5 minutes.
Between the two of you.
Enough. Great.
I'm very deeply obliged.
Grateful.
My lord, item number 9, the side is here. We are requesting if it can be taken up on 7th, your lordship.
7th, 9, 7th.
Item 9, 7th.
Item 7, 9th or 9, 7th?
No, 7th August.
7th August.
Item number
Item
9,
number.
7th.
9, 7th.
At the cost of being reprimanded, my lord, item number 10 to 14, my lord, I'm been led by Mr. Mitro, Mr. Obreid Mitro, senior advocate, my lord. At
Mr.
Obreid Mitro, senior advocate,
Yes.
he was there from the morning to do the matter, my lord, but 2 p.m. he will not be available, my lord. If you kindly, Thursday, my lord, if it takes.
Who is the other side?
Other side, my lord.
I'm appearing in one of the appeals, my lord.
Our is the main appeal. We are the applicant before the trial court.
There are total 5 appeals, my lord. Before
We are the petitioner before the.
No, unless you get consent from all the parties, you come at 2 o'clock, tell us, we'll adjourn. Talk to all of them. You don't do this like this.
Sir, my lord has already given that leave, my lord, from the urgent determination of Justice Bhattacharya. It's appearing in a non-commercial list of item number 2, my lord. The already demolition work, my lord, has.
So what will we do? We'll hear it now?
Some, my lord, precedence tomorrow, my lord.
Non-commercial. হবে তো কমার্শিয়াল শেষ হয়ে গেলেই তো হবে, আজকেই তো হবে, কি আছে? Oh, for filing written note.
Hearing was 1 and 2, my lord, led by Mr. Owen Banerjee, my lord.
Hearing was concluded, it is for filing of
Written notes.
Very well. কিচ্ছু লাগবে না. Written notes of arguments filed on behalf of the parties be kept with the records. Paragraph. Judgment hearing is concluded. Judgment is reserved.
দিয়ে দিয়েছে, নাম দিয়ে দিয়েছে, নাম দিয়ে দিয়েছে, অয়ন ব্যানার্জি।
Item 3.
Much obliged.
My lord, I am appearing on behalf of the petitioner in the contempt application.
Appearing on behalf of the Lordship calling application of the disposal of contempt filed by the Lordship private respondent in the region.
How is this maintainable, Mr. Mujumdar?
Yes,
That was your Lordship's view that in a contempt application there is nothing to do by the private
My
respondent.
lord, this proceeding is in between the petitioner and the contemptor.
First, show me the order of which violation was alleged in the contempt petition, the parent order. Show us.
Page 82
82 of your application,
of the recalling application.
of the recalling. সেটা কত can? Can 1? '82 is the last page.
80. 80.
80. You were not a party in the writ petition.
No,
you were not a party. Who is Habibur Rahman?
Habibur Rahman is the writ petitioner.
You are Habibur Rahman.
Yes.
Say so, I am Habibur Rahman.
Yes, sir.
And only official respondents in the writ petition, or they were private respondents?
There was no private respondent.
No private respondent. Very well. Allow us to go through the order.
Yes, my lord. The private respondent was made a party in the writ petition.
হ্যাঁ, লেখা আছে।
পার্টি করেন না, তখন বলছিলাম পার্টি ছিলাম, পার্টি ছিলাম। ওদের শুধু পার্টি ছিল না।
Very well. Now, alleging violation of this order, you filed a contempt application.
Yes.
Where is the order on the contempt application?
Contempt application order is, my lord,
90.
page 9. Relevant paragraph is, my lord, 5. Inner page 3.
Ali Hafiz was the private respondent in the writ petition.
Yes, my lord.
In the
Then you say you were not a party, Mr. Mujumdar?
No, not in the contempt. I mistook
No,
it.
on
In
the
the appeal, I was the
contempt, of course.
respondent.
Yes. Challenge that order if you are aggrieved. There is no question of recalling this order.
Not two things, not which has been suppressed in the contempt application.
Maybe it is between the petitioner and the contemptor and the court. Suppression, no suppression. There is an order by the Gram Panchayat.
Not which was challenged in a separate writ petition.
Fine. What happened?
In that writ petition, now what has not been pointed out to your lordship is the pendency of the writ petition number 1. Number 2, in which an exercise has already been undertaken by the competent authority under the amended laws. Now that gives power to the SDO to take a final decision on this issue. Not Pradhan is not the appropriate authority or competent authority under the Act anymore after 2018. Now, what has happened in the meantime? An inspection was directed to be carried out on notice to the writ petitioner from which this appeal has arisen. Suppressing all these facts, this contempt application was taken out, and your lordships were persuaded to pass this order in execution of the original order.
There's nothing to persuade. The order, our order, had two parts. One is decide the representation. Second is if you find there's illegal construction, take steps. When the contempt was moved, an affidavit was filed by Pradhan. We found that she has passed a reasoned order and therefore consequential direction.
Please have a look at this particular provision.
Maybe.
Your lordship clarified in your lordship
in
order.
the contempt, nothing. You see, we have only directed the implementation of our earlier order.
Now,
if you are agreed with our earlier order, ask for recalling of that or take it up in appeal.
That's right. Not only one thing which requires your lordship's kind consideration is this. Not your lordship had directed conferred power on the Pradhan to pass an appropriate order in light of certain observations, or not in the light of the complaint made. Now, that order passed by the Pradhan is under challenge.
Yes.
In that an exercise has already been undertaken. But please have a look at
whatever the effect in law is, Mr. Mujumdar, it is, we are not recalling this order.
At the time of passing this order in contempt, while exercising contempt jurisdiction, the lordship probably did not have the occasion to be assisted with this provision.
The provision may say SDO is the ultimate authority.
But after 2018, this has changed.
Right. SDO may be appropriate authority. You have to ask for recalling of the parent order. Not in contempt. We shouldn't even allow your client to poke his nose in this contempt. So either you withdraw this or we will dismiss this. Better, because we'll make observations which may not be palatable to your client. You take steps in accordance with law. We'll reserve that liberty to you. Or let us record a one-page order saying that according to us, this is not maintainable. You will be at liberty to challenge the parent order. Should we do that or do you want to withdraw? Ask your instructing advocate.
To decide the grievance to approach. But if your lordship will kindly have a look at page 80.
Then we will record an order.
No, kindly only one sentence.
Yes.
But lordship may straightway come to page 81.
Yes.
Before us, the last paragraph on that page. Before us, it has been stated by the parties that after the order under appeal was passed, an order dated July 15, 2022 has been passed by a learned single judge, filed by the private respondents herein challenging revocation of permission. So, your lordships were considering a stage where the permission had been revoked. Permission granted in their favor by the Pradhan of the Gram Panchayat for making construction on Dag number so and so. The said writ petition was disposed of by the said order dated July 15, 2022 by granting liberty to the writ petitioners therein, who are the private respondents before us, to approach the Pradhan with a representation which has to be decided in accordance with law. We are of the view that the Pradhan would be the appropriate authority to decide the grievance of the present writ petitioner also. Accordingly, we grant liberty to the writ petitioner to make a representation to the Pradhan of the Panchayat, who is respondent number 7 before us, within 3 weeks from date. If such representation is made within the time indicated, the Pradhan shall dispose of the same in accordance with law by a reasoned order within a period of 2 months from the date of receipt of such representation. after giving an opportunity of hearing to the writ petitioner and the private respondents herein as also to any other concerned party. The decision so taken shall be communicated to the parties within a week from the date. Needless to say, if the Pradhan finds merit in the complaint made by the present appellant, appropriate remedial steps will be taken by him or her. We have not gone into the merits of the respective cases of the parties. The respondent number 7 shall take an informed decision in accordance with law. Since we have not called for affidavits, the allegations are so and so. So, not after the order, the parent order, this order of at page 80 is passed. Not we have taken a remedial measure to challenge that order in a writ petition. So, not page 80 did not stand in our way or did not affect our rights per se. But this process we have carried out to challenge this order passed by the Pradhan.
Carry that process to its logical conclusion.
Yes, and not in the meantime, not if this contempt jurisdiction is exercised to the extent of demolishing the construction, not kindly not stage this for some time then.
Side, no, Mr. Majumdar, no.
Not please, not the parent order only directs the Pradhan to dispose of a representation.
Whatever flows from the parent order flows. If in any way you are unhappy with it, ask for recalling of that challenge.
I am not aggrieved by the parent order. Your Lordship has please come to page 82 once again.
We are not saying anything, and particularly in a recalling in a contempt made by a party, not a party to the contempt petition.
Designation of an application, your Lordships have repeatedly held, not the 2008 judgment of our court.
Very well. Do we record an order or you withdraw?
Only one sentence. No, right, I'm trying to persuade your Lordship. To the extent of, apropos your Lordship's observation as to whether we are aggrieved by this order or not. Please come to page 82 once.
Yes.
The penultimate paragraph beginning with the words needless to say. It is the 4th or 5th line.
You just placed it.
Yes. If the respondent number 7 finds merit in the complaint made by the present appellant, appropriate remedial steps will be taken by him or her. Now, apropos this, please come to page 90.
7 was the Pradhan.
Pradhan. He was directed to take remedial steps.
Yes.
Now, please come to page 90.
Yes.
But after this order is quoted at page 91.
Yes.
In paragraph 3. We find from the affidavit filed by the contender number 2 in response to the rule that the alleged contender number 2 has passed an order dated March 24, 2025 recording that unauthorized construction or illegal construction has been raised at the instance of the person responsible being Ali Hafiz. By the said order dated March 24, 2025, the alleged contender, that is the Pradhan, called upon Sri Hafiz to demolish the unauthorized construction within 15 days. It further appears that a copy of the said order, which is really a self-demolition order, has been forwarded to Hafiz and the present petitioner. Learned advocate for the petitioner says that although 15 days has elapsed long ago, neither Hafiz demolished the unauthorized construction nor the Panchayat has taken any step. We direct the Pradhan to demolish the unauthorized construction following due procedure at the cost of Hafiz. We clarify that the Panchayat will be at liberty to recover the cost of demolition of the unauthorized construction from Hafiz. But in between these two orders, the SDO had called the parties at the hearing. My learned friend's client has appeared and not that proceeding is on.
Not in connection with his matter, my lord.
And please have a look at page 80.
Why haven't you demolished till date?
Lordship, the problem is after passing of the order in terms of 23(5), Lordship, we have forwarded the order to the sponsor SDO.
Very well.
Because Lordship, what happened? The private respondent took a permission from the Maju Gram Panchayat and constructed house in the Sialdanga Gram Panchayat, which is not in our jurisdiction. So, Lordship, the initial sanction plan was obtained by misrepresentation of fact. Therefore, Lordship, we cancel the sanction plan, pass an order that the SDO should take 2 steps accordingly. Therefore, Lordship, the jurisdiction is, Lordship, with the Sialdanga Gram Panchayat. That in the new writ application, they challenge the order. They have implemented the Sialdanga Gram Panchayat as party.
Sure.
And in the new writ application, the SDO has, Lordship, called for a Lordship hearing.
Mat 1034 of 2022 was disposed of along with the connected application by an order date by a judgment and order dated August 2, 2022. Stop. The present applicant was the private respondent number 10 in that appeal. Stop. That appeal arose out of a writ petition whereby the writ petitioner sought for demolition of alleged unauthorized construction raised by the private respondent number 10 in those proceedings. Stop. Not having obtained favorable order, comma, the writ petitioner approached the appeal court, which passed the order dated August 2, 2022. Stop. Paragraph. The order dated August 2, 2022, records that from the affidavit of service filed in court today, from the affidavit of service filed in court today, it appears from, it appears from the affidavit of service filed in court today that the private respondents have been served, stop, however, they are not represented, stop, unquote. Paragraph. The operative portion of that order reads as follows, page 82 থেকে set out. Paragraph. Alleging willful violation of that order, the writ petitioner filed a contempt application being CPAN number 94, CPAN 94 of 2023, rule was issued.
Yes, rule was.
Which was renumbered as CRC 12 of 2024 after issuance of rule. Stop. The Pradhan of the concerned Gram Panchayat was respondent number 2 in the contempt application. Stop. The Pradhan filed an affidavit
Page 91, that's it, third paragraph.
No, ছেড়ে দাও প্রধান ফাইল অ্যাফিডেভিট কেটে দাও paragraph. The contempt application was disposed of by an order dated June 17, 2025, the operative portion whereof reads as follows. Page 91 থেকে paragraph 3, 4 and 5. Set out. Paragraph. The present application has been taken out for recall of the order dated June 17, 2025. Stop. The applicant says, who was the private respondent number 10 in the aforesaid writ proceedings, correct?
Respondent number 9.
9, আগে যেখানে 9 হবে. Says that certain very material facts were not placed before this court when the order dated June 17, 2025 was passed. Stop. More particularly, an order of the concerned Gram Panchayat revoking sanction of a building plan that had been granted in favor of the present applicant, has been challenged in a writ petition before a learned judge of this court. Stop. The writ petition is still pending. Stop. If in the meantime the alleged unauthorized construction in question is demolished, the writ petition will become infructuous and the applicant will suffer serious prejudice. Paragraph. We are of the view that the present application is not maintainable. Stop. The order of which recall is sought, was passed on a contempt application to which the applicant was not a party. Stop. In the contempt application, we were only concerned with whether or not the parent order dated July 15,
2nd August 2022.
August
2nd 2022.
August 2, 2022 was violated or not. Stop. We found that the alleged contempt number 2 had passed a reason order in terms of the parent order and had also issued self-demolition order against the person responsible. Stop. All we did was to direct the alleged container number 2, being the Pradhan of the concerned Gram Panchayat, to fully implement the parent order dated August 2, 2022 by completing demolition of the unauthorized structures. Stop. We are not inclined to entertain the present application paragraph. However, we clarify that if the law, the applicable law requires the concerned SDO, subdivisional officer, to take a final decision in the matter of demolition of the concerned structure, such decision shall be taken before demolition is implemented. I think that is the most you can get.
My lord, if your lordship kindly...
Such decision be taken by the concerned subdivisional officer within a month from the date of communication of this order by the writ petitioner to the subdivisional officer. Paragraph.
But he has already initiated such action.
Enough.
No, not in connection with this matter.
Number to dekhe na is disposed of. Number disposed of.
Grateful, your lord.
Mr. Mujumdar, your client got full relief actually. What's your name?
Matter item 10 to 14.
Well, these are my appeals, my lord.
The first item number is my appeal.
Yes, an accommodation was sought for.
Yes. Well, for item 11, Mr. Mitra is leading me in the matter, my lord. My lord, he wishes to advance arguments, my lord.
So anybody, any objection to the adjournment?
My lord, we don't object to the adjournment. My lord, my appeal is the first appeal. Mr. Bachawat is leading me. We would, my lord, request that we be permitted to start first because we'd also.
Where is he?
May
I believe, my lord, is on legs elsewhere.
Then
my lord, may I the section 9 application on the basis whereof, my lord, this.
Mr. Sen, we are adjourning. Not today. Not today.
My lord, could it be, if it commenced to my lord's convenience, my lord, could it be on Thursday, my lord? If
Thursday? Not today means Thursday. Not today. Tomorrow is original site. No chance.
Would it be a lordship's pleasure to record, my lord, that the adjournment was sought for by them because we are under.
Accommodation is sought for on behalf of the appellant in.
I'm happy to start. Appellant in item 11.
You are Pradyumna Kumar Mishra.
Yes, ma'am.
In FMAT 345 of 2023. Stop. Paragraph. Let these matters একসঙ্গে হচ্ছে কি তাই হচ্ছে be listed again on Thursday date করে দাও.
I'm grateful, man.
Please give your appearance before disappearance.
May it please your lordships.
You are for the appellant. একশোটা অর্ডার রেকর্ড রয়েছে কিন্তু কোনোদিনই আর্গুমেন্ট হয়নি Your 34 was dismissed.
My 34 was dismissed from that.
You had furnished bank guarantee 19 crore 11 lakhs. And then you have secured the amount here also in this court.
No, we have paid them. They have filed a counterbank. Oh, I understand in this matter because we have paid them. They have furnished a counter guarantee.
Oh, I see. You have paid them. They have furnished. No, but this order, 13th August order records the appellant being the award debtor had furnished security in the form of bank guarantee before the learned court below.
Then mother, I have to check.
So this is what is recorded.
Must be the must. Must be. In even my lord, I do not think on that count there is any.
Anyway, today whatever is happened, who is for the respondent?
For the respondent, my lord, my senior is appearing through.
My lord, in this matter, the senior.
Why on the virtual mode?
My lord, actually, my
Where
lord.
Is he not in Calcutta?
My lord, I'm in Calcutta, my lord. Actually, in this matter, my lord, the senior counsel Sohail Dutt from Supreme Court, my lord, is appearing, my lord. So, my lord, praying for any date for my lord a time, so he can come down and argue the matter, my lord. So.
তাও একটা 2 সপ্তাহ বাদে টাইম দাও একটা বাইরে থেকে আসছে ফিক্স করে দাও
On that point, my lord, may I, my lord, take my lord to page 570 of the paper book. The 13th August order, lordship would find at internal page 2 that records that the Registrar Commercial Court at Asansol is accordingly directed to transmit the bank guarantee to the appellant by 29th August 2024 The respondent shall furnish the Registrar General of
কি
the court
করছো?
a bank guarantee.
টাইম দেখতে বললাম। কত? আচ্ছা,
Noted. 29
12th August. Yes, 12th August, Mr. Singh.
My lord. My lord.
This is a 37, na? তো টাইম নেবে 19 কোটি টাকার অ্যাওয়ার্ড at কি বার 12th August 3:30.
I will only indicate, my lord, I have no issue with 3:30. I will take some time. I will take
No,
some
we can't give you the entire day, Mr. Dash.
No, that, but
Then we'll have to give you another day.
yes, that's I.
That's all right. You have to do কি করবো ঠিক আছে লিখতে হবে কিছু না করে দেবে না লিখলে এদের সুবিধা হবে we were also on the other side at some point of time. লেখো learned advocate for the respondent says that learned senior counsel from Delhi will argue this matter on behalf of the respondent. Paragraph, let this matter be listed again on August 12, 2025, marked 3:30 p.m.
My lord. Much.
Number 17.
My lord, supplementary affidavit, supplementary paper book, and the application is filed only today, my lord. That has not come perhaps from the department. So, my lord, praying for only one day.
Last option, give them file an application for additional ground.
Yes.
That application is filed today only.
Has been filed.
Yes, my lord. Today in the morning. That.
But I have gone through. But I seek your lordship taken up this application along with that.
Yes, it is not before us also today.
Yes, that's
not today only, we'll see. So it will come day after tomorrow. It will now.
My lord.
Great. Go.
Passover matter, item 1 and 2.
I appear for the appellant, my lord. This matter was.
Which one?
1 and 2.
Oh, this is the matter where, yes, learned counsel from Delhi had appeared for filing of written note. File.
Before
no, sorry.
For the other way.
We have to release this matter.
My lord, extremely sorry, my lord. In the previous matter, my lord, the item number 15, instead of my lord 12, it can be the my lord the 19th, subject to convenience of this court, my lord.
Yes, 19th.
Much.
19th. একবারে 19 December করে দাও।
I would suffer.
19th August. Release. Acha, this matter was heard substantially. This matter was heard substantially by another bench, bracket Amara Rai Madam Namdida. And in fact, hearing was concluded. Stop. The matter was directed to be listed only for the purpose of filing written notes of argument. Paragraph, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. Please write to the Chief Justice Secretary with a copy of this order. As soon as the assignment comes, we will constitute a bench and we'll take your notes, reserve judgment.
Controversial matter, item number 1.
Affidavit of service be filed in court on the next date. Next, this matter, how long will you take to serve?
My lord, I will serve it tomorrow as soon as order comes.
Next Tuesday. List the matter under the appropriate heading.
Grateful. Madam.
True, my lord, I beg to represent the state lordship.
This is my appeal.
My lord, I have a point of maintainability in this writ petition, lordship.
Why is it not maintainable, Mr.
As
Khalid?
because, my lord, my learned friend is inviting your lordship's jurisdiction or judicial review from a decision or adjudication of the learned tribunal. As on date, there is no decision, no adjudication. Simply filing, getting a date, coming to your lordship.
Let us see the impugned order.
No impugned order as on date. Paragraph 18 is paragraph 18 is the reason.
18th August is the date fixed.
Paragraph 18 is the reason. So if that be so, it will kill the soul of L. Chandra Kumar's judgment.
That's right.
At the most expeditious hearing, I don't stand in the way. I don't stand in the way.
Yes, Mr. Mujumdar. We'll prepone the date.
Even injunction application not moved.
But the tribunal gives a date on 18th of August.
Preponement.
Not in that event. No. Not if L. Chandra Kumar has to be obeyed in its true sense.
3 weeks left only.
No, not in the direction is to demolish it immediately. Tomorrow is the date for.
It has been going on since July in compliance with the court's order of Honorable High Court's order.
Which is the order which has been challenged before the tribunal? Show us.
Yes. Please come to not the report of the
page 109.
109.
Who is now the chairperson? Justice Dashgupta?
Yes, Lordship.
The date fixed was 14th of July.
Yes. We filed the application before the learned tribunal.
Yes.
No.
I'm not.
Previously High Court. Kindly see page 15. Kindly see page 15, 1-5.
The court was pleased to take notice of the liberty was granted by the court. Please come to the internal page. Paragraph 5 at page 16.
Yes, naturally. I mean, that is always open to you.
And we are acting on the basis of page 106. We are acting in compliance with 106. No appeal therefrom till date by the appellate.
But we have filed an application, original application before the learned tribunal, seeking to challenge the decision of the government.
But there is no stay, Mr. Mujumdar. You have not filed an injunction stay application or injunction application.
The original application contains a prayer for stay. Please come to page 6.
Where it starts from page 18, 1-8.
3-1.
Interim order staying the operation.
So
what we will do, Mr. Ghalib, we'll request the tribunal to consider this prayer of theirs as soon as possible, preferably within 10 days from the date of communication. If they succeed, if they get an interim order, your hands will be stayed naturally.
Certainly, my lord, I can't stand in the way, but this very prayer which my learned friend is trying to urge before your lordship could have been placed before the tribunal. See, the registry has given the date in August. Kindly prepone the date because we are facing demolition. This could have been placed before the tribunal.
But I wish my learned friend said this also for the state
The
administrative.
profession has to go on, Mr. Galib.
I am also too. Yes, I am also getting some from this. Kindly prepone.
Prepared for lordship. It's such time that the issue of interim order decided. No issue.
Kindly prepone. Let there be an adjudication.
Yes, but point is till then, don't take step. This is what we'll have to say. Otherwise, if you demolish before that, what remains?
Not at all, my lord. They are not the only persons.
So just that
I'm
limit.
concerned with my house.
Limited
14th
protection.
July.
You listen to what we are saying. Listen to what we are saying.
14th July operation started. Till date, nothing means nothing.
No, we were not parties to that.
You could have
But the
preferred
problem
an
is-
appeal on the basis
problem
special leave
is-
to appeal.
When it comes to right to shelter, the only judgment that comes to our mind is Olga Tellis. But we can't cite that in court because at least I don't understand the purport of, the spirit of the honorable court's
The
judgment.
present petitioner has filed this writ petition. Now, the present petitioner has filed an original application being OA number 2050 of 2025 before the West Bengal Land Reforms and Tenancy Tribunal, bracket A, in short LRTT, challenging a 7th July notice. Where is it?
So that's at page 1.
109, lordship.
109.
109.
Challenging a notice dated July 7, 2025, issued by the Block Land and Land Reforms Officer, Barakpur-Roman 1, North 24 Parganas. Stop. The operative portion of the said notice reads as follows. Page 110 থেকে আমি মার্ক করে দিলাম প্যারাগ্রাফ, একটা ছোট্ট প্যারাগ্রাফ আছে, একটু সাবধানে করে এটা মেলাতে পারবো না আমি, হ্যাঁ? Paragraph. Learned advocate for the learned senior counsel. I'm very sorry, Mr. Mujumdar.
No, we are all advocates.
Learned senior counsel for the petitioner says that although the original application was filed on?
It was on, my lord. It was filed on 21st July 2025.
July 21, 2025, the matter has not yet been heard. Stop. The matter has been directed to be listed on August 18.
19.
August 19, 2025. Stop. Date for demolition of the alleged unauthorized structure is tomorrow.
It is on. The operation is on.
Oh,
Just outside
Not
my
of
house
him.
now.
Not of his, others.
For demolition of the
alleged unauthorized structure of the petitioner is tomorrow.
It's going on, no, it's
My lord, since the other
Your structure?
it's outside my house now. No, I apprehend it to be tomorrow.
restoration of water body, lord.
The demolition process has been started by the authorities. Stop.
Demolition, not restoration of water body.
Acha, the process of rest. So have you? Then your structure has to be demolished, no?
Restoration can only be done by
After
demolition.
demolition.
No, lordship, order of this Honorable High Court is
Demolition
for restoration of
process.
water body.
Demolition process in aid of restoration of the concerned water body has already been initiated by the authorities. Stop. Any day the structures raised by the petitioner will be demolished, although they are not illegal structures. Stop. In effect, the petitioner prays for an early hearing of the original application. Paragraph. Mr. Galib, learned counsel appearing for the respondent authorities, only state.
Only state, Lordship.
Respondent authorities fairly says that he cannot possibly oppose.
There is only one private respondent, respondent 10.
For the official respondents, Gaurav. He possibly cannot oppose the prayer for expeditious hearing of the original application. Paragraph. We find that there is that in the original application there is a prayer for ad interim order of stay of operation of the notice dated July 7, 2025. Stop. We request the learned LRTT to consider the original application of the petitioner and in particular the prayer for interim order as early as possible and preferably within a fortnight from the date of communication of this order. From the date of communication of this order. Stop. Needless to say, if the petitioner succeeds in persuading the LRTT to interfere with the notice under challenge as an interim measure or otherwise, the state authorities shall have to abide by such order. Stop. If the petitioner is not able to obtain a favorable order, the state authorities shall be at liberty to act in terms of the notice dated July 7, 2025. Paragraph. We clarify that we have not addressed the merits of the case at all. Stop. WPLRT is accordingly disposed of. Stop. Since no affidavits have been called for, the allegations contained in the petition are deemed not to be admitted by the respondents.
I appear except 6, 7 and 10.
I submit only this. I am sorry.
6, 7 and 10.
Except. Are 1 to 5, 8 and 9. Yes?
I was only on this, not apropos the default clause. In the event of our failure to obtain an interim order, suppose not we approach your Lordship's court and persuade, and are able to persuade your Lordship's court that the refusal of interim order was not done in a that will give probably a handle to the authorities.
My lord, let the adjudication comes, my lord.
Very nice. Shall be at liberty to notice dated, tarpore, naturally subject to interdiction by any higher forum. Don't look so unhappy. We have not done something.
Lordship is relegating the matter to the tribunal. Let
Yes.
it decide first, then
That is
we
what
have
we
the
have said.
remedy always, Lordship. Either we or they.
We have not granted any relief to them.
No, subject to, my lord, the last word, my lord, the sentence, my lord.
No. If they are unable to obtain interim order there, they have a right to approach us again.
My lord, that goes without saying, Lord. We have learned from you. That goes without saying, my lord, whether liberty given or not given, Lord. Kindly, my lord.
Till a decision is taken on the petitioner's prayer for interim order, no coercive measure be taken by the state authorities in respect of the petitioner's property.
But in terms of the order of 14 July, 7 July 25.
No coercive step. In the context, it has to be in
So,
terms
Lordship,
of.
in that event, could have, my lord, kindly, my lord, I was having a point of demeral, Lordship. In this case, my lord, he is obtaining an interim order, Lordship. Since, my lord, we are also acting, my lord, in
Mr.
compliance
Galib,
with, my
please
lord,
understand.
kindly appreciate one thing on our
You
conduct.
please understand one thing. You are not opposing a prayer for early hearing of the interim order?
I'm not on. I'm not. I don't say oppose, my lord. I say, my lord, this application should have been for expeditious. Not that I'm not opposing.
We'll
but
treat this as we are treating it as that.
no, but lordship, since I am on the point of maintainability, that since there is no adjudication, there is no subject matter judicial review by your lordship. So, my lord, since he's getting an interim order in this application, can you kindly appreciate my lordship?
What have we done? For 10 days, you are not demolishing. That is all we have done. They have approached a tribunal. The tribunal has given a date after a month. We have preponed that date and said, till that date, do not take any action. That is all.
Since, my lord, I have the point of maintainability of this particular petition, lordship. So, kindly, my lord, decide, my lord. Kindly decide. I'll just quote two provisions from the West Bengal Land Reform Tenancy Tribunal and one judgment,
A
lordship.
writ petition in our equitable jurisdiction, we will treat not passing an order, interim order.
No, lordship, kindly appreciate. We have learned from you, lord, equity cannot supplant law, my lord.
No, it is.
Equity can supplement law, but not supplant law, lordship.
Not supplanting law in this case.
Lord, I request my learned friend to consider a situation.
No, all
A
right.
government employee files an application for challenging an order of transfer before the state administrative tribunal.
My
There
lord,
is no bench
Chandra
available.
Kumar is very much clear.
that-
There has to be adjudication or decision, my lord.
Mr. Gali, Supreme Court, please. Please.
Lordship.
Lord, in fact, paragraph
Yes, it's if you think obviously you think this is an erroneous order. Nothing stops you from going to the Supreme Court.
Since I had a point of maintainability, lordship.
We are not inclined to even if we hear you for 2 hours on that. What we have done, we think that is the fair and equitable thing to do. We have not granted any substantive relief. All we have said, decide his prayer for interim order, and naturally, till such date, don't demolish his structure.
Lordship, may I pray for one sentence, lordship?
Yes.
Since your lordship has been pleased to grant interim order of no quasi measure.
Yes.
So this observation of your lordship will not prevent the, my lord,
Absolutely.
the tribunal to decide the stay application
And
on merit, independent of any, my lord.
We have only granted a breathing space to the petitioner to enable it to try enable him to try his luck before the tribunal insofar as obtaining interim order is concerned. Stop. The limited protection that we have granted will not be taken into consideration by the tribunal in deciding the petitioner's prayer for interim order.
Independent of this.
And the petitioner's prayer for interim order, stop. The learned tribunal shall take a decision independent of our order and not being influenced by any observation in this order.
And he shall not claim any equity also on this basis, lordship.
Stop. This limited protection granted by us shall not create any equity in favor of the petitioner.
Smiling.
Next.
No, lordship. May the report be retained with the record, lordship? The state authority has given me one report.
Report.
May it be retained with the record, lordship.
Report filed by the state respondents be kept with the records. Dispose of করে দিয়েছি তো।
Lordship, I appear on behalf of National Stock Exchange, Your Lordship.
On behalf of?
National Stock Exchange.
Very well.
My lord, I filed this petition.
Oh, this is restoration নাকি? কোথায় restorationটা কোথায়?
Not been served a copy of the application, Your Lord.
You have not served a copy, sir.
Pardon, sir.
You have not given her a copy of the restoration application.
I'm appearing in person. Already copy was served, inspection was done. Thereafter, I was sick, so
বুঝিয়ে দাও. Restoration petitioner copy.
they submitted some document that was inspected. Thereafter, one day I did not come, so that day it was rejected, dismissed.
You have not engaged a learned lawyer.
No, sir.
You want?
I am appearing in all the time.
All
In
the
this
time.
case, I'm appearing in all the court by myself.
You prefer that. What if we arrange for legal aid free of cost if some lawyer appears for you?
So then from legal aid, it should be given. I cannot bear the cost.
That is right.
I'm a super senior citizen. But it is a very simple matter. I was doing all this
Sir,
job
please,
for
please,
last 10
please.
years. This one. This case from 2015, I'm dragging on this case.
আপনার কাছে রেস্টোরেশন পিটিশনের কপি আছে?
আজকে আনেনি, আজকে অরিজিনাল পিটিশনটা নিয়ে এসেছি।
The petitioner is appearing in person. Stop.
Original petition.
We are of the view that it will be helpful for both for him and the court if he is represented through a learned lawyer to be engaged by High Court Legal Service Authority. High Court Legal Service Authority. Paragraph. We direct the member secretary of the High Court Legal Service Authority to engage a learned lawyer to represent the petitioner. Stop. Let a copy of this order be immediately forwarded to the member secretary of the High Court Legal Service Authority to do the for the purpose of doing the needful. For the purpose of doing the needful. List the matter 1 week hence. কিন্তু উনি তো বোঝাতে হবে জনকে যেতে হবে।
Okay, thank you. Meanwhile, I get the assistance of a legal aid advocate.
এদিকে আসুন, আপনাকে বলছি।
Number 4, my lord. Bolo. My lord, I am for the respondent, my lord. I am led by Mr. Devjit Mukherjee. He is having a fever, my lord, so he couldn't come to court, my lord. I will pray for 1 day accommodation, only 1 day.
Thursday. Not today.
Requesting your, my learned friend.
Not today.
Only 1
On the prayer made on behalf of the respondent, let this matter stand adjourned for the day.
ঠিক আছে।
My lord, I appear for the petitioner. My lord, this is an appeal from an order passed by the learned single judge refusing to pass any order on my application made under Section 8 of the Arbitration and Conciliation Act, on the basis of which I prayed for stay of the suit because there is an arbitration agreement by and between the parties.
Finally disposed of, Section 8?
Yes. Now, my lord,
refusal to applicable. The reference to capital rates. If Section 8 is allowed.
Well, we preferred an appeal before this instant appeal, before I show your lordship, my lord. It's an appealable order.
No, we were just checking whether if allowing an application under Section 8 is also appealable or not.
Refusing.
Only refusal. Yes.
My lord, will see on this appeal when we initially moved, an interim order was passed on the 21st of January 2025. My lord will find it in my lord's records. First 3 paragraphs is, of course, condonation of delay. The delay crept in because by mistake, or by wrong advice, my lord, a revisional application had been filed, which was dismissed and liberty was given to us to prefer the appeal. Prima facie, we are satisfied. My lord has got the order of 21st January 2025 passed by the division bench. It must be in your lordship's record.
Yes.
Kindly read from paragraph 4. Prima facie, we are satisfied that the parties are bound by the arbitration clause in the Memorandum of Understanding. In fact, the plaint also refers to the Memorandum of Understanding. However, it is alleged that the defendant number 2 has no authority to enter into a Memorandum of Understanding on behalf of the plaintiff. The Memorandum of Understanding is dated 30th March 2012, which bears the signature of the defendant number 1. The connection with the defendant number 1 with the other plaintiffs is not disputed. The suit is for eviction of the defendant number 1. The defendant number 1 could not have been in possession other than in implementation of the Memorandum of Understanding, and as such, it is relevant at this stage to consider whether the suit was filed to bypass the arbitration clause. On such consideration, there shall be a stay of operation of all further proceedings entitled suit number 532 of 2015. And then, my lord, directions for affidavits were filed. My lord, the existence of the arbitration agreement has been admitted in the plaint, which I shall show your lordship. But before that, may I just show your lordship what is the Memorandum of Understanding which incorporates the...
We are effectively hearing the appeal then.
Yes. Do you mind if I do it tomorrow?
Yes.
Well, I shall be very...
Yes, let us not start today.
We have started.
Oh, we have started, of
Yes,
course.
we have started.
How unreasonable of me to say.
The meter has been put on.
Of course.
Mr. Bosman.
Shiggiri lekho, Abhijit. Lekho. It is understood that the appeal and the connected application are being heard together. Stop paragraph. Mr. Bose, learned senior counsel representing the appellant begins his argument but does not conclude. Paragraph lists this matter once again on.
But the day after tomorrow is an appellate side day.
Are you pursuing the other?
Pursuing. Very grateful to me. Grateful.
Hey, Shuno. As the first hearing matter, since we are taking up the appeal as the first hearing matter. Just to put you on notice, because of administrative reasons, we'll be rising fairly early today, 10 to 4.
Start to no.
Yes, yes.
That really wanted to go.
It's on my old iPad. But I have everything here. check. Sign.
Conclusion.
There is. Okay, it's connected. No, that's okay. That's okay. ठीक है ठीक है ठीक है.
How many?
Physical briefs, my lord, we couldn't have this confusion. Now, my lord, with the iPads, we have. Which iPad has the
No, no, I have it in both. But
it leads to confusion actually. Which iPad has the brief? Then, my lord, which one you made little note of, which has not been
no,
made?
I
The
have.
other one.
My lord, I have my notes. The only thing is I don't have the list of dates in one. My lord, I believe, my lord, the list of dates is already with your
Yes, yes,
lordship.
it's on record.
If that is there, my lord, yes.
Yes.
Now, my lord, since my lord, my lord, start de novo, my lord, in this. It's yes. Now, my lord, can we share a joke? I told Mr. Banerjee that, my lord, the suggestion from the bench that, my lord, it starts de novo is because, my lord, there's a very hardworking junior judge, my lord, in the
Absolutely right. I'm not a hypocrite.
So, my lord, may I just indicate?
You can scarce afford to say, probably one of the hardest working people I have seen.
My lord, life is not easy always, my lord. And people enjoy hard work also at times.
Sure.
Up to a point.
গরম হচ্ছে হার্ড ওয়ার্ক হয়ে গেছে গরম হচ্ছে চলো তো পা চলো চলো
There's other ways to cool people down. It's pouring cats and dogs out.
কি এসি কি কাজ করছে না কি বলতো এসি
Probably colder outside because of the torrential downpour.
Pouring hard.
Yes, Mr.
my lord, 25th November 2016 and 1st December 2016 are the two important dates. My lord, SICA was repealed, my lord, on 25th November 2016. And my lord, IBC came into force on 1st of December 2016. And my lord, there was, my lord, a provision that where if a reference was pending, my lord, before BIFR on that date, then within a particular period, that's 180 days from the commencement of IBC, my lord, a petition could be filed, my lord, to start the corporate insolvency resolution process under section 10, where the company itself, my lord, applies. So, my lord, on, my lord, 2nd of May 2017, the company itself, my lord, made, my lord, the, my lord, application, my lord, under, my lord, IBC. Now, this wayleave permission which the company was enjoying for, my lord, the underground water pipeline, my lord, had not been in use since 2010, but its validity was till 2017. So, my lord, this 2017, my lord, your lordship will find 25th, date number 15, 25th May 2017, my lord, was our application. And my lord, our wayleave permission, my lord, expired, my lord, on 9th of July 2017. So, my lord, the section 10 and the BIFR, my lord, were, my lord, both proceedings instituted during the validity of the wayleave permission. Now, my lord, what happens thereafter? My lord, after 2017, my lord, a wayleave permission, my lord, was, my lord, granted, my lord, to, my lord, Odisha Metallics Private Limited for construction of a road under bridge. That your lordships will find, my lord, on 1st of February 2019. And my lord, kindly note one thing, my lord. This was on the basis of an application. Kindly see the date against item 13 made before expiry of, my lord, my wayleave permission. So, my lord, on 2nd May 2017, while the wayleave permission for my lord, underground water pipeline was pending, my lord, they had applied. And after it had expired, my lord, they were given, my lord, the wayleave permission, my lord, on 1st of February 2019. Now, my lord, note another thing. My lord, on 1st of February 2019, my lord, my lord, petition for, my lord, corporate insolvency resolution under section 10 got admitted. Your lordship will find that, my lord, date number 17, 8th January 2018. So, my lord, my application was before expiry. My lord, after expiry, my lord, my lord, application was admitted. And after it was admitted, on the basis of an application made during the validity of my wayleave permission, my lord, the respondent number 1, my lord, Odisha Metallics, was granted railway underbridge wayleave permission. And my lord, 2019, my lord, they were granted this permission. And my lord, an agreement, my lord, was executed with the railways. Now, this underbridge permission, my lord, went over a portion of railway land under which, my lord, my pipeline was there. My lord, from 2010. Now, my lord, all this happens. Now, my lord, the resolution process, my lord, starts. My lord, who bid? My lord, there were two main bidders. My lord, for, my lord, the, my lord, Ram Sarup. My lord, my client was one of the bidders, and, my lord, Odisha Metallics Private Limited, the writ petitioner. The writ petitioner lost out. I got, my lord, the resolution insolvency. My lord, I was the successful resolution applicant. Now, my lord, what happens? My lord, there is also material to show that, my lord, they were not happy with this, and I'll place those orders. They, my lord, wanted the company to go into liquidation. That's Ram Swarup. OMPL wanted Ram Swarup to go into liquidation, and, my lord, had seemed to proceed on the basis that, my lord, in liquidation they would buy. So, my lord, they were interested, my lord, in, my lord, buying, my lord, or getting control of, my lord, Ram Swarup. Quite understandable also, because they were neighbors, my lord, the factory premises. My lord, orange is Ram Swarup, the other, my lord, is, my lord, them. Blue color. But, my lord, they failed there. My lord, we got, my lord, the corporate, my lord, we came in, my lord, as the new avatar, as the successful resolution applicant of Ram Swarup. So, my lord, we, my lord, applied for revival of this water pipeline, because it was important for us to have, my lord, this water pipeline for, my lord, carrying on business and reviving, my lord, Ram Swarup. Now, my lord, permission was granted by the railways. After considering, and I'll show that, my lord, all, my lord, diagrams, inspection, my lord, surveys, my lord, we were granted, my lord, permission. My lord, when we started, my lord, repairing the pipeline at one or two places where, my lord, there was some damage, and, my lord, the railways said, look, don't go under the underpass, don't disrupt them, just take the span over for only that section. My lord, your lordship will see the two spans, there were two areas. You just take it over that, and on that basis, my lord, work had happened. Then, my lord, they moved, my lord, the writ court, saying, look, this could not have been done without consulting us. What has been done is in violation of the railway code. And, my lord, what has been done is in violation of a railway board circular, because you could not have migrated to the new policy under that, because on the date this permission was granted, your old permission had expired. This was, my lord, the case which they had done. Now, my lord, now two facts, my lord, I just wanted to point out. My lord, the total length, my lord, of the pipeline, and kindly bear this in mind, is, my lord, 2250 meters. My lord, the entirety of this originally was underground. But because of two way-leave permissions given in the year 2019 and 2022, a total of, my lord, 38 meters had to be above ground. So, my lord, in effect, 1.7% of the total length of the pipeline had to be overground. And the reason for that, my lord, and the railways have said so on affidavit, was that there would be no, my lord, either damage or obstruction to the railway underbridges for which way-leave permission had been granted to the respondent number one. So, my lord, there is, my lord, that those spans which your lordship sees. One is, my lord, of, my lord, a total length of, my lord, 10 meters, and the other is, my lord, 18 meters. No, there are two 10-meter spans, and, my lord, one 18-meter span. So, my lord, a total of, my lord, 38 meters. Correct. Correct. Yes. So, my lord, it's two spans, my lord, 10 meter, 18, and keeping, my lord, the gap, my lord, between them. I'll just show the gap between them, my lord, it was 38 meters. Because, my lord, every, my lord, overhead, my lord, had, my lord, a concrete, my lord, underground structure. I'll show that, my lord, in the next model. My lord, 2.5 meters each. So, my lord, that was, my lord, 5 meters and, my lord, 5 meters. So, another 10 meters, my lord, got added. My lord, that's how, my lord, it was. Now, my lord, if I may take that back and give your lordship this model, which will show me.
Mr. Bachawat, all yours.
I don't have any young children at home. Otherwise, this would have been fun.
Now, my lord, kindly note one thing. My lord, the grey pillars, my lord, your lordship sees, my lord, the grey pillars under, my lord, the yellow and green is underground. This is the concrete, my lord, which holds up, my lord, the RUB, my lord, is, my lord, where the trucks are. My lord, they go underground this. And, my lord, the pipeline is above that steel structure. And, my lord, there's a 500 mm, my lord, gap between the steel structure and, my lord, the underpass.
Tunnel is there. Hey, Rotnanko, I can't see the tunnel. That's exactly what we're saying. You can't see the tunnel. It is not effective.
My lord, this is, my lord, how it is. Now, my lord, most importantly, আচ্ছা চলো চলো ও রত্নাঙ্ক সঙ্গে ওইদিকে আড্ডা করো যাও ওইদিকে যাও
এই গাড়িগুলো রেখে দাও
Don't work on power. Only pushing power. He's asking what?
Now, my lord.
Yes. And on top of that, the cars go railway track also.
That truck chilo. My lord, we had handed up certain photographs on the last occasion. I don't know if they're there. Yeah. My lord, if it's not there, your lordship might have given it back. Yes. Yes. Now, my lord.
Side is the railway.
Now, my lord, kindly let me point out 2 or 3 things. My lord, if your lordship's looking at the picture, my lord, if your lordships, my lord, see the picture, on the right-hand side, your lordships will see, my lord, a pipe. My lord, that is the pipeline which is going above, my lord, the underpass.
I wasn't coming to court.
No, now, my lord, the interesting thing is, above the underpass, there is a road. My lord, on, my lord, which, my lord, vehicles, my lord, travel. There is also, my lord, the railway tracks. No damage to, my lord, underpass. Kindly bear that in mind. Cars go up and down. My lord, trains go up and down. And, my lord, at the start of the underpass, my lord, we have, my lord, my lord, overground, my lord, pipeline, which is 10 meters in one case, 18 meters in another. And, my lord, kindly note, the pipe doesn't even touch the underpass and is, my lord, in a steel structure, which is 500 mm above the underpass, supported by concrete, my lord, work, which has been done underground, not on the railway line, which protects their underpass because it's concrete, my lord, on the sides now, not, my lord, just, my lord, the, my lord, soil. So there is no problem. There is no problem, my lord, with vehicles plying. There's no problem, my lord, with the train plying. Though the tracks are directly on the underpass, the road is the ceiling of the underpass. Kindly, my lord, bear this in mind. Now, my lord, and my lord, this is the other picture. Did we hang this up? Huh? Was this handed? আগে দেওয়া হয়েছিল তো আগের বার। হ্যাঁ, my lord, this one you'll also your lordships have.
Possibly not.
বেড়ে গেছে।
এই এগুলো একটা ফাইলে রাখুন, নাহলে আবার ছেড়ে যাবে।
Because this was also handed up, my lord, on 8th of July 2025. And my lord, copy served, it's my lord written. My lord, their plant, my lord, we've written OMPL plant. My lord, RIL water pipeline. And my lord, this is the road. This doesn't show the sumo, shows a motorcycle. And my lord, this is the train. So train is going over it. So the underpass comes out on the other side. Now, my lord, this is, my lord, the factual scenario. Now, my lord, kindly come to, my lord, the impugned order.
Next day.
Yes.
এগুলো নাও।
My lord,
Copy
your
one.
lordships desire that, my lord, we prepare, my lord, a folder for the photograph so that it doesn't get torn. My lord, এখানে রাখুন, আপনার কাছেই রাখুন।
রাখো, কবে দেবে? রাখো, ডায়েরিটা খোলো।
ম্যাটারটা নেক্সট কবে সেটাই জানতে চাইছি।
My lord, also, is it your lordship's desire that Mr. Banerjee makes one more scale model and gives it to us?
No, my lord, there's one thing which is very important. The one who, my lord, the one who wants to play with it is Mr. Bachao.
I'll tell you why. You know what I'm tempted to do? I'll tell you, lordship, what I'm tempted to do. Ekbar scale model now, just like they went and dug into not mine. I want to demonstrate what that digging is on that model. রত্নাঙ্ক, খুব ভালো হয়েছে কিন্তু মডেলটা। আরেকটা বানিয়ে দাও। কেন করবো?
You will take about an hour?
Yes, my lord, I need two full, my lord, 315 sessions, my lord. I should.
5 তারিখ আর কবে দিতে পারবে বলো? 6 তারিখ? 7 তারিখ?
5 take or 3? वो 5 मिनट में
5th and 7th.
5th, my lord, your lordship.
5th and 7th, 3:30, both. Tuesday and Thursday.
I'm not there.
Yes.
Not Friday. Tuesday and Thursday.
I mean, but
Mr. Mukherjee, our learned senior counsel representing the appellant, resumes his argument but does not conclude. Resumes Borona. Starts his argument afresh since this is a differently constituted bench. Stop. He does not conclude. Paragraph. List this matter once again on August 5. তাই তো? 5 তারিখ তো? Mark 3:30 p.m. 7 তারিখটা তুমি লিখে রেখে দাও, কাউকে দিয়ে দিও না।
Which matter is this?
Yes.